Morning.
Good morning.
I want to call the meeting to the order. Uh, Roll call, please. Why, this thing is giving second time?
Dr. Bolak,
Here.
Judge Feinstein, Dr. Hawkins,
Here.
Dr. Kraus,
Present.
Ms. Lawson,
Here.
Dr. Levine,
Here.
Dr. Lewis,
Present.
Ms. Pines,
Here.
Ms. Sutton Wills,
Here.
Mr. Warmouth,
Here.
Ms. Wright, Dr. Yip, Dr. Gonadev.
Here. We have quorum, so if we could take care of that feedback. Oh, yeah.
What is plugged in now that wasn't
I still hear it intermittently, like a little pop.
Okay.
Clean right now. It's still clean. Clean? Yeah, it's clean right now. Yeah, it's still clean.
Okay, yeah, it looks, well, 19th century technical problems in 21st century, so. Good to see room full. Thank you all for coming. Please silence your cell phones. You may notice board members accessing their laptops during the meeting. They are using the laptops for the purpose of assessing board materials. This is an official meeting of the Medical Board of California, and as such, disruptions of the board's business will not be tolerated. We have a designated time on the agenda for public comment, and I ask for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct him or herself in such a manner that permits the board to transact its business. This meeting will be available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconference process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, please press *1. You will hear a tone indicating you are in the queue for comment. If you change your mind and do not want to make a comment, press *2. Assistance is available throughout the teleconference meeting. To request a specialist, press *0. Each person will be limited to 3 minutes per agenda item. During agenda item 10, public comments on items not on the agenda, the board has limited the public comment period for individuals on the teleconference to 20 minutes. In addition, the public comment from the individuals here at the meeting will be limited to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During public comment on any other item, 10 minutes will be allowed for comments from the individuals on the teleconference line and those in the audience. After 10 minutes, no further comments will be accepted. Business services staff will be assisting me with receiving the public comments via teleconference during this meeting. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on the agenda item and you wish to speak on that item, please raise your hand or come forward and you will be recognized. I would like to request all speakers to complete a presenter slip so I can call you by name at the appropriate time, and that the record of this meeting can be full and complete. However, this is voluntary. Please give the speaker slips to Ms. Cruz Jones, right there. I will do my best to call upon everyone who has supplied a slip for the agenda item and recognize those who wish to make last-minute comment. We plan to end the meeting before 2 p.m. today. I'd like to ask Ms. Kirschmeyer to introduce any individuals in the audience.
Good morning. I would actually like to introduce Janelle Jackson, who's here from Assembly Member Shirley Weber's office. Thank you for coming. And then we also have, just one moment. And then we also have in the audience Dean Grafilo, who's the Director of the Department of Consumer Affairs, and with him is Chris Castrillo, who's the Deputy Director at DCA. We also have Jessica Sieferman, who's the Executive Officer of the Board of Optometry. And then I'd really like to welcome, especially in light of our discussion yesterday, all of the students that were here from Midwestern. So there's a whole room full today. So welcome here, and we're so glad you're here.
Yeah, welcome, guys. We love to have you. It's good to start right now before you get licensed. So we don't want to get into trouble. So I'd like to call we did the roll call already. I would like to remind members again that we will be taking roll call vote on all the action items. Moving to agenda item 10, public comments not on the agenda. Do we have anybody Janelle, you wanted to say something? Please come on.
Is this on? Okay. Good morning, everyone. On behalf of Assemblymember Weber, who is speaking at an educational event this morning, welcome to San Diego. For those that don't know, Assemblymember Weber was elected in 2012 to serve for the 79th Assembly District, which you are currently in. It's a large district of about 500,000 people, very diverse economically, educationally, and just want to welcome you to San Diego. Please do not hesitate to reach out to us if you have any questions. I don't believe any of Dr. Weber's bills have gone through your board, but in the case that it does, it's very great to be here to listen to the process. Thank you.
Thank you. Thank you for coming. Please convey our respects to the Assembly. Okay, I have a couple slips. Alicia, KBLA Radio, I'm sorry, I didn't want to mess up your last name. Come on in, please.
My name is Alicia Alarcón. I have been a radio talk show host for the last 15 years in Los Angeles, California. And today is a very, very important date for you and for thousands of people in Southern California. Because today you will have the opportunity to exercise your power. You will exercise your power over an individual who, as far as I know, has done a lot of good. And I refer to Dr. Mahfouz Michael. I have
I'm sorry,
known.
ma'am, but if you're speaking about a case that may come before the board for their vote, we have to ask you to stop.
Oh,
You can speak in generalities, but not about a case that is pending for decision.
I'm ready. I was ready to speak about what Dr. Michael has done. That's my only purpose to be here, to
I
drive
can't have
2 hours.
you do that, ma'am, because the members can only hear the evidence that is
Not
presented
even I
by the
can
ALJ.
say what my experience, what has been with him, or what he has done in the community, the good he has done. So I cannot speak about that.
I'm sorry, ma'am, but it's a case pending before the board members,
Well,
so I
when
have
you
to
s-
ask you not to.
Okay, when you say generalities, what do that mean? The weather, what do
Can't
you mean?
speak about the physician.
Okay, so I can speak about anything else without saying the name? No?
Please
Okay.
don't, ma'am.
Okay, so then that means that since my whole objective and purpose was to speak about what he has done, so I cannot do that. Is that correct?
That is correct.
Okay.
And there is an appropriate opportunity for you to present evidence and represent for him. And I would recommend that you contact the Deputy Attorney General who's handling the matter, and they will be the ones that will
Yeah, I'm-
lead you in that process.
Yeah, not exactly to present evidence. I was just giving my testimonial
Right.
and the testimonial of my listeners of the good
And a
things that he has
reference
done.
that would go to that individual to talk to them,
Okay,
okay?
thank you very much.
Thank you. Thank you
Thank
for
you.
coming, though. Next one is Hector Pacheco. Mr. Pacheco.
Good morning. My name is Hector Perez Pacheco. I'm a county commissioner for Los Angeles for the for the Community Action Board, as well as commissioner for the Workforce Investment Board. And I'm just here to share the importance of having more community clinics and speaking and working with the communities to address the issues of diabetes and obesity. My family has experienced this tremendously, and there's not enough education that's taking place within our communities, the underserved communities within Los Angeles and the greater area. So I just urge that there's a stronger emphasis on individuals that are committed to making a difference within the communities in terms of providing education on diabetes and obesity. So that's my purpose being here, is to educate and to bring that awareness to others. So thank you.
Thank you. Thank you so much. I think you got, it's one of the biggest problems in the country. We appreciate that. And anything we can do, we'll do. It's usually the other agencies rather than the medical board which gets involved with that education, but we'll do whatever it takes. Thank you.
Thank you.
Next one is Amber Lopez.
Good morning, Chairman. President.
Good morning.
I have some prepared, but then this is close. But one of the things that I am from El Sereno, I'm the honorary mayor of El Sereno, is 67,000 people. They always need help. They need the physicians, they need the providers, and sometimes when we have needs, I really love when the doctors, they go to my town. And that is one of the things that I know the board always take care of. They see what is the people good and what is the people bad. But the beautiful thing that I've been learning through all these years is people give opportunities, and then those opportunities change in life. And when that change in life, we bring families. Without health, without any provider, we are not have a case. And especially now in these days, which is very difficult to go forward. My people, which is El Sereno, is, I can tell you, is low income. Sometimes they don't have the money not even to pay the health. And we need those physicians that actually they put their heart on it. When they put their heart on it, I see my people happy. I can tell you many things about my people, but I love my people. That's why I'm here. Because when I see something that is an error for one time, but it's not difficult to fix it. That's why I trust my board. That's why I trust you. I put my hands for you, because on you is my people's health. And thank you. And I can tell you that I'm so happy that I'm here to speak on behalf of my people.
Thank you. Next one is Mahmoud Michael.
Thank you for allowing me to come here. I believe I cannot talk on behalf of myself, just as you said, but I do plead that you support my employees, my doctors, my patients. Thank you.
Thank you. Next one is Dr. Ree.
Ma'am, I just want to make sure, in case you didn't hear, you may not speak about a case that's pending before the board.
Yes, thank you very much for that clarification. I had heard it earlier. So certainly, I don't, of course, want to speak about that, but on the other hand, I'm wondering if perhaps I may be able to introduce myself.
You can state your name, but please don't speak about a case.
Okay. So, my name is Hannah Rhee, R-H-E-E, Dr. Rhee. I'm a primary care physician in the state of California. So I was going to, as an addition, mention that I'm currently under investigation with the board.
Ma'am, you may speak about generalities and processes, but please don't speak about your individual case.
Yes, thank you. Thank you. I appreciate that information. So I am concerned that there is an unintended bias and discrimination against the elderly and the disabled in the actions and the decisions of the Medical Board of California. Again, I'd like to emphasize something in the medical literature which is often described as an implicit bias. Oftentimes, as we go about our lives and our jobs and follow the letter of the law, it sometimes may be relevant for what's referred to in medicine as retrospective data analysis. And so certainly in what may be described as an anecdotal reports of sorts from other physicians who have come before the Medical Board of California, defending their actions and addressing complaints.
Ma'am, you must conclude.
Thank you. So I wanted to state again to the board, to the Medical Board of California, that I'm very concerned that there is an implicit, unintentional bias and discrimination against the elderly and the disabled in the state of California. Thank you very much.
Thank you, Dr. Ray. Any other comments from the audience? Comments on the phone?
Yes, there are two on the phone. The first one is from Eric Andrist. Your line is now open.
First, I'm due 35 additional seconds after Carrie cut me off prematurely yesterday. I believe Carrie is wrong to keep telling speakers they can't speak about open complaints. It's my understanding from the law that that's not true. While she has to give the disclaimer that they don't want the board to hear about open cases, members of the public are allowed to speak about anything they want at a public meeting. You can't silence the public, Carrie. Under the Brown Act, during a regular session but not during a special session, the public has the right to comment on any item of interest to the public before or during a legislative body's consideration of that item. That is within the subject matter jurisdiction of the legislative body. This right has been construed to mean that there must be a period of time provided for general public comment on a matter within the subject matter jurisdiction of the legislative body, as well as an opportunity for public comment under each specific agenda item as it is taken up by the body. Under the Brown Act, the right to comment includes the right to comment on matters to be considered by the body in closed session. I would also like to request that someone other than Carrie Webb monitor the stopwatch for speakers. Deb announced a 3-minute speaking time, and the first two callers yesterday, including myself, were cut off just after 2 minutes. I have video proof that I'm uploading to YouTube and will be filing a Brown Act complaint. As I understand it, she also cut Marianne Hollingsworth off later in the meeting. I also noticed that almost every time I call in, Deb smirks when my name is announced. Not only does he do that, the more he does that, the more Carrie Webb illegally denies Public Record Act requests, the more Kimberly Kirkmeyer ignores all of my emails, the more incentive gives me to watch every move the board makes and bring it to the public's attention. I can't understand why other members on the board listen to these accusations and sit back and do nothing. Why isn't Judge Feinstein all over Carrie Webb breaking the Public Records Act? Why do you all allow Deb to stay on the board with all of the information we've brought to your attention? If you think I'm wrong about this stuff, just look it up. The more you ignore these issues, which affect your ability to truly do your job, the more you're going to keep hearing from me. The information is ready for you to see. Be responsible. I'm very serious in my role as a patient safety advocate. You may not like what I say or my approach, but your responsibility is to still listen and respond professionally. not ignore me like I'm an annoying fly in the room. Thank you. And Carrie, stop cutting people off prematurely.
Thank you. Next one.
Next comment is from Shalina Garza. Your line is now open.
Hello, this is Dr. Shalina Garza. Thank you for allowing me to speak this morning. I would like to identify myself as a frenemy of the California Medical Board and patient safety advocate. My comment this morning is regarding the mental health of physicians and public disclosure. There are two scenarios that I would like to outline and provide some recommendations to the medical board, and also request that this subject be placed on the agenda for the next meeting. The first scenario is when a physician who has a mental health illness is found to be functionally impaired to the level of incompetence. It is justifiable then, in that particular case, for the medical board to remove that physician's license. However, the disclosure of the mental health information online is inappropriate, and it is also illegal because the medical board has already protected the public to the fullest extent that it could protect the public in this circumstance by removing the license. In the second scenario, when a physician who has a mental health illness that doesn't rise to the level of functional impairment or incompetency, the medical board also cannot provide this information to the public because the only thing the public can do with this information is discriminate against the physician, which is the exact scenario that the Americans with Disabilities Act was intended to prevent. So in summary, I would like to say that the medical board has a responsibility and an obligation to protect the privacy rights of every individual, including physicians, and the public disclosure of mental health information needs to be evaluated on an individual case basis, and lack of resources to do that is not an excuse for breaking the law. Thank you.
Thank you. Any other comments on the phone?
No further comments at this time.
Okay, so the agenda item 11 is postponed to the next meeting. Apparently, the speaker has her plane diverted, so she can't be here. So, yeah, so Kim, please go
I
ahead.
did just want to comment to the members, though, that it is actually going to be open enrollment. I think it begins November 1st for the Stephen M. Thompson Loan Repayment Program. So if you have individuals that you think should be applying for that, and again, I put that out to the individuals that are also here and anybody else that's listening, that open enrollment does start November 1st, and that's kind of what Ms. Asbrick was going to talk about, as well as the whole Health Foundation education program. But I did want to let everyone know that that is open starting November, since we won't get that opportunity before it probably closes.
Yeah, even for the members in the audience, especially from the communities where the underrepresented minority communities, make sure that a doctor practicing there can apply for the loan repayment program. That's what it is created for, mainly for primary care doctors who are taking care of poor people or in the rural areas. So make sure that you pass the message on to the doctors. Many doctors don't even know that they can get funds from that program to pay back some of the loans. We'll take an agenda item early, the 17 first. That is update from the Department of Consumer Affairs, which may include updates pertaining to the department's administrative services, human resources, enforcement, information technology, communications and outreach, as well as legislative and regulatory policy affairs. That's from Mr. Graffalo and Mr. Castillo. P, welcome.
Good morning, Medical Board of California. President Gananadev, Vice President Pines, Executive Director Kirchmeier, esteemed members, thank you for the opportunity to provide a department update to the board. This is now my second time addressing you all, and since the first, I've continued to truly enjoy my time serving as director. As you know, there have recently been changes at the department, as well as at the medical board. Your executive director was able to grab a true talent in Christine Lally, who previously served as the department's Board and Bureau Relations Deputy Director. I know Ms. Lally will do great things for the board as its new Deputy Director. She was a force at DCA, and I know she'll even be a greater force for the medical board. Additionally, the department is welcoming a new Chief Deputy Director, Chris Schultz. I'd like to first thank Jeffrey Mason, the current Chief Deputy, for his time served and his dedication to DCA. The department will also be having a new Deputy Director of Administration, Natalie Daniels, and a new Deputy Director over Board and Bureau Services, the gentleman to my right, Chris Castrillo, who will speak to you all momentarily and will mention other additions to the department. In reference back to Mr. Chris Schultz, before coming to DCA, Mr. Schultz has been Deputy Commissioner of the Community Programs and Policy Initiatives at the Department of Insurance since 2011 and will begin with the department this coming Monday. Ms. Daniels has been a fiscal supervisor at the Judicial Council of California since 2015 and will be starting with the department on November 7. She will be overseeing the department's Office of Human Resources, Business Services Office, and Fiscal Operations. In September, this past September, the second Directors Quarterly meeting with board executive officers was held. We're very focused on ensuring the department continues an open dialogue with its boards and bureaus, and to that end, we will be holding an annual meeting with all board presidents to ensure I'm available to you and I can hear feedback from board leadership on the important issues facing the department and its boards and bureaus. One of the important items announced at the meeting that I would like to share with you is that DCA released a new online license verification search for all boards and bureaus using the Breeze platform. I think even Google would be impressed. The license search will expand current functionality to allow the public more flexible search capabilities. The new search allows inline filtering on a range of relevant data points, including primary and secondary status, city, county, and license type. A key focus for the new search is the user experience. Performance, flow, and ease of use are our primary targets. The new DCA search brings our offering closer to familiar search capabilities common across the internet, allowing our stakeholders the data they require at their fingertips. Before our new Deputy Director of Board and Bureau Services introduces himself, I would like to make sure that you all know that the department is committed to serving its boards and bureaus. Much of the consumer protection value provided through the department comes through boards, definitely through the Medical Board of California. We always protect consumers better when we are working strongly together. Thank you again.
Thanks, Dean. Well, as you are aware, we have some new faces in the DCA Executive Office, and as one of those new faces, I wanted to take the opportunity to introduce myself. My name is Christopher Castrillo. I was appointed to the Office of Board and Bureau Services on October 9th, 2017. Folks can also refer to me as the new Christine, as I have been referred to more than a few times. And as I've come to learn, Ms. Lally is a difficult person to replace at DCA, and just would once more like to take the opportunity to thank her for her service, and I wish her the best in her new role here at the Medical Board. So I come to DCA with a background in public policy and campaign management, having most recently worked as a legislative advocate where I covered a variety of policy areas including labor, higher education, youth mental health, foster care, and local government, to name a few. I have also worked on candidate and initiative campaigns in both California and Oregon. While new to the DCA family, I'm greatly looking forward to applying my experience and skill set towards establishing an Office of Board and Bureau Services that implements the goals laid out in the strategic plan, exemplifies organizational effectiveness, and provides relevant, timely, and accurate information to all of our stakeholders. We are also looking forward to Karen Nelson and Patrick Lee coming on board as our Assistant Deputy Directors for the new Office of Board and Bureau Services. Mr. Lee has been Assistant Chief of External Affairs at Covered California since 2015 And Ms. Nelson has been Chief Operations Officer at the American Leadership Forum Mountain Valley chapter since 2014. We are very excited to have them aboard, and you'll be hearing from them after they begin their service on October 30th. With our new staff structure, I believe we will be able to further the vision, mission, and values we have set forth as a department, and most importantly, serve the needs of California consumers. Please stay tuned for additional updates from me as I continue my transition into my new role and as our office fully takes shape. With that, would like to provide just a couple of quick updates to the board. DCA leadership training. The department officially kicked off its new Future Leadership Development Program in May 2017 and held the kickoff meeting with program participants and mentors in August 2017. The last meeting of the FLD participants was this Tuesday, October 24th, with Senator Jerry Hill. Expanding upon the department's current Leadership Academy training, the department is looking to help develop the best and brightest among the department and its boards and bureaus into our future leaders. The program includes executive mentoring, customized leadership training, and project management. I'd also like to take this opportunity to thank member Denise Pines for participating in the Future Leadership Development Initiative training on October 11th, 2017, and for speaking to our mentees. I had the opportunity to be there, and it was fantastic, so thank you so much. I would also like to thank Kim for helping set up that event and for serving on our steering committee. Thank you, Kim. Pro Rata. The department has established a Pro Rata work group of DCA and board executives to discuss potential improvements on how DCA communicates with boards on this issue. Pro Rata is the process which the department distributes the costs amongst its boards and bureaus to cover all departmental services such as IT, legal, public services, and the like. The work group held its first meeting in August 2017, and our next Pro Rata workshop will be held on October 31st. The department's also going to be hosting a Pro Rata open house, and that's going to take place on November 14th. In July, the department released its new strategic plan. Like the board's strategic plan, the department's executive team developed it with the assistance of Solid, and it outlines DCA's goals and objectives for the next 4 years. The plan is available on the publications page of the DCA website. Couple quick reminders here. Required board member trainings. The final board member orientation training is scheduled for November 15th. There's still room in the class if you need to register. Board members are required to complete this training within 1 year of appointment and reappointment to the board. This is a one-day training in Sacramento which details the important functions and responsibilities of board members. Please contact DCA's Solid team if you are interested in attending, or board members can also register online. And finally, a reminder that 2017 is a mandatory sexual harassment prevention training year for the Department of Consumer Affairs. This means all employees and board members are required to complete this training in 2017, even if it was completed last year. The training is online, interactive, and can be completed at your convenience. If you have any questions on any of this or any of the required training during your tenure as a board member, please don't hesitate to contact the Office of Board and Bureau Services for assistance. As always, if the department can be of service to the board, please let us know. Thank you for your diligent work and your valued partnership, and I'm really looking forward to working with you all. Thank you so much.
Thank you, Dean. Thank you, Chris. Any questions from the board? Comments? Okay. And any public comment from the audience? Comments on the phone?
Yes, there is one from Eric Andrus. Your line is now open.
First of all, Mr. Graffalo, the new DCA search function is only moderately better than the old one. The font is extremely tiny and difficult to read, especially for people with vision disabilities. That's not considering your consumers. Our website, which mirrors the medical board's disciplinary actions, which is located at bit.ly.com/doccot, is far more consumer-friendly, and you'd all be wise to take a look and see how a website should actually work. I have a question for Mr. Graffalo. Why is it you ignore emails from consumers? I have sent you a lot of emails showing you how the medical board is breaking the Public Records Act, and you haven't replied once. As the head of the Department of Consumer Affairs, you should be listening to your consumers, not ignoring them. Do consumers you don't want to hear from get put on some kind of blacklist to ignore all their emails? Thank you.
Thank you, Mr. Andrus. Anybody else?
I'm showing no further comments.
Thank you. Thank you, Dean. Thank you, Chris. Thanks for coming. We'll go to item number 12, discussion and possible action on recommendations from the Special Faculty Permit Review Committee. Dr. Bola.
Thank you, Dr. Gananadev. So the Special Faculty Permit Review Committee held a teleconference meeting on October 11th, 2017. And at that committee meeting, we reviewed and discussed Dr. Stefano Palanti's application for a special faculty appointment with Stanford University School of Medicine. And for board members, please turn to BRD 12-1 and 2 in your meeting packet for a detailed report on Dr. Palanti's medical school and postgraduate training. In summary, Dr. Palante specializes in the area of psychiatry, specifically in the area of severe comorbid psychiatric disorders. Dr. Palante has a long and distinguished career in psychiatry. He has held the position of a tenured professor of psychiatry at the University of Florence since 2001 and serves as chair of education and director of the psychiatry program. His extensive portfolio of scholarly work has focused on the underlying neurobiology and treatment of major psychiatric disorders. He has an excellent record of accomplishment of extramural research funding as principal investigator from both government agencies and industry, and has more than 180 peer-reviewed articles in journals. He has held visiting professorships at Stanford, Harvard, Mount Sinai School of Medicine, Albert Einstein College of Medicine, University of California Davis School of Medicine, and Imperial College of London. Dr. Palante serves on the editorial boards of several scientific journals and has served as editor-in-chief for the Italian edition of the American Journal of Psychiatry. If approved by the board, Dr. Palante will hold a full-time faculty appointment as a professor of psychiatry at Stanford University of Medicine. He will provide clinical care in the inpatient and outpatient psychiatry clinic at Stanford University of Medicine, along with other facilities affiliated with Stanford University of Medicine. Dr. Palante will provide expert leadership in the area of complex and severe comorbid psychiatric disorders. Stanford University of Medicine has a strong clinical need for his expertise in psychiatry and his programmatic leadership. The committee recommends that the board approve Dr. Palante for a special faculty permit appointment.
So moved.
Second.
Any comments from the board? Comments from the audience? Comments on the phone?
Showing no comments at this time.
Roll call, please.
There's a hand.
Oh. Please come in.
Yes, hello again. I'm Hannah Reed, Dr. Reed, and I thank you for letting me speak. A very brief comment. Of course, we depend on our teaching institutions. The best medical care is in the United States, and as I reflect on my own training, looking to institutions such as Stanford and the what we refer to as the big name hospitals and systems and that kind of thing, I do have a concern. I do have a small concern that maybe perhaps it may be time to reflect on the necessity of having medical board members with extensive hospital affiliations. I'm wondering if perhaps there could be an unintentional implicit bias in the decisions of the medical board in terms of these hospital affiliations. So I thank you again.
Thank you, Dr. Ree. Any other comments? Roll call, please.
Dr. Bolat?
Yes.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Dr. Gonadev?
Aye, the motion carries. We'll go to item number 13, update from the Application Review and Special Program Committee. Ms. Lawson.
Good morning. The Application Review and Special Programs Committee met this morning at 8:30 a.m. Dr. Hawkins and I were present and established the quorum for the meeting. In a closed session, Ms. Alameda presented one physician and surgeon application, and the committee made a recommendation to the executive director, and the meeting was adjourned. It's my brief update.
Thank you, Ms. Lawson. Boy, if we move like this, we'll be done by noon. Any comments from the audience? Any comments on the phone?
No comments at this time.
Thank you. Next, we'll go to the item number 14, update, discussion, and possible action on the recommendations from Midwifery Advisory Council meeting. Ms. Perwan?
Good morning. My name is Carrie Sparavon. I chair the Midwifery Advisory Council to the Medical Board. I have one amendment to the report that was in your packet, which is that the interested parties meeting to discuss changes to the licensed midwife annual reporting tool was canceled due to all of the fires in Northern California, one of which was threatening to come onto my territory. So we kind of canceled it at the last minute, and it's still to be rescheduled. Hopefully we'll get it in before the end of the year, if not early next year. I'd like to also highlight the American River College Midwifery Education Program that's in the process of being created. It will be only the second community college program in the country and the first one in California. I think it will bring a new level of academic leadership in midwifery care for California midwives, and it will also open the door for midwifery students who can't afford the current schools, because it will be offered at a community college price, and they will be eligible to get federal financial aid to attend. So I look forward to updating you continually on this as it moves forward. We're looking at a projected opening date of fall of 2019. I need approval, please, on the following agenda items for the next Midwifery Advisory Council meeting to be held in December. Task force update on revisions to the Licensed Midwife Annual Report, an update on continuing regulatory efforts required by Assembly Bill AB 1308, update on the Midwifery Task Force, an update on the hospital transfer form, update on midwifery-related legislation, update on the progress of midwifery assistant regulations, which I believe I got an email, they were all approved. Yay. Open Meeting Act presentation, to update new council members to the specifics of the Open Meeting Act so we can all be in compliance. An update on the board's midwifery program, and another update on the community college licensed midwife program. So I need a motion to approve those.
Second.
Okay, any questions or comments from the board members? Dr. Hawkins.
Just a question about the program starting in the community college. Community colleges are more subscribed to in part because of their flexible schedules and reduced costs. But I know in Southern California, Los Angeles County, often there's a backlog of classes and classes are really full. Do you anticipate any problems with those issues occurring as you open this program in community colleges?
We're aware of those concerns. At this point, we're not real sure how many applicants we'll have for the program. We can look at, for instance, the statistics on our licensed midwife annual report that shows as more midwives were licensed, more midwifery clients were served. So we can expect that because this program will be so much lower in cost than any of the other available programs, that there might be a huge influx of students. The program is going to be designed to be at a distance. So that will open the way for some of the prerequisites to be taken in an individual student's community. So American River itself won't be 100% impacted by students needing things like anatomy and physiology specifically from them. They can go to, San Diego's community college or Los Angeles Community College to get those. So it will kind of spread that out. The coursework will be primarily online with some on-site clinical classes to prepare students for their clinical preceptorships. We're getting a lot of input from a lot of people. A lot of brainstorming is going into this, and I thank you for bringing that up, because I know that particularly for nursing students, it's a huge problem to get into programs, and we should be so lucky to have a really long list of people wanting to be licensed midwives in California. Thank you.
Thank you. Any other comments? Any comments from the audience? Comments on the phone?
No comments over the phone.
Okay, roll call, please.
Dr. Bolat?
Yes.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson? Yes. Dr. Levine?
Yes.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
Ms. Wright? Excuse me. Dr. Gonadev?
Aye, and the motion carries. Our next agenda item is an update and possible action and recommendations from, Midwifery Task Force, Dr. Bolat and Dr. Levine.
Thank you, Dr. Godanadev. The Midwifery Task Force met via conference call on October 5th, 2017, and the task force discussed the regulations required by AB 1308, that's Bonilla Chapter 665 Statutes of 2013, and possible next steps. First, I would like to provide some background information to provide context. AB 1308 was signed in 2013, and it removed the physician supervision requirement for licensed midwives and required licensed midwives to only accept clients that met the criteria for normal pregnancy and childbirth as specified in this bill. If a potential client does not meet the criteria for normal pregnancy and childbirth, then the licensed midwife must refer that client to a physician trained in obstetrics and gynecology for examination. The licensed midwife can only accept the client if the physician examines the client and determines that the risk factors are not likely to significantly affect the course of pregnancy and childbirth. This bill required the board to develop regulations specifying any pre-existing maternal disease or condition likely to affect the pregnancy. The board convened 2 interested parties meetings in an effort to develop regulations, and there was agreement on many of the pre-existing maternal diseases or conditions likely to affect the pregnancy, but the outlier was vaginal birth after cesarean. This is the one condition that could not be agreed upon. Both sides felt strongly about this issue and put the board's regulatory process at a standstill. Because of this, board staff went to the board and asked for the board's assistance at the Midwifery Task Force was appointed.
The Midwifery Task Force, consisting of Dr. Bolat and myself representing the medical board, met on March 6, 2017 with interested parties. At that meeting, the parties discussed the challenges created by the current language in Business and Profession Code Section 2507B2, requiring the physician who performs the examination to make a determination, and that's the key word, determination, before the fact that the risk factors presented are not likely to significantly affect the course of pregnancy and childbirth. The task force was informed by interested parties that requiring physicians to make this determination puts the physician in a difficult position. And it was acknowledged that the issue could not be resolved. The issue of the language around determination could not be resolved through regulations, and that statutory changes would be necessary. Proposed language was provided and discussed at the task force meeting. Board staff then made changes to the language based on input received at the meeting and recirculated the language to all involved on March 28, 2017. The proposed language would require the physician to assess the risk factors instead of making a determination. The licensed midwife would have to include the physician's assessment in evaluating whether the client's condition or disease would likely significantly affect the course of pregnancy or childbirth. The licensed midwife would be held to the same standard of care as anyone providing delivery services. Proposed language was presented to the board at the April 28, 2017 meeting. The board approved the language and authorized staff to submit the language to Senate Business Professions and Economic Development Committee for possible inclusion in the board's sunset bill. Board staff did provide the language to Senate B&P staff as directed. On April 17, 2017, Senate Bill 457, authored by Senator Bates, was introduced. This bill was co-sponsored by CMA and ACOG and completely would completely eliminate the section of law that the medical board's language would have amended. The bill would have the same requirements for everyone attending to cases of out-of-hospital births, whether they are physicians, certified nurse midwives, or licensed midwives. It would have also changed the Midwifery Practice Act to limit the licensed midwife care to out-of-hospital childbirth and prenatal, intrapartum, and postpartum care related to out-of-hospital childbirth. This bill became a 2-year bill before our meeting on April 28th, so it was not brought to the board for evaluation and potential taking a position. Since this board meeting, this October board meeting, is a time to discuss potential proposals for next year, the Midwifery Task Force had a conference call with board staff on October 5th, 2017, to talk about potential next steps. Task force members and staff discussed moving forward with the board's language, but in the face of the fact that there is a bill that would make changes to and essentially delete the section of law that we would be amending, this made no sense at this time. After discussion, we believe that the most appropriate course of action is for board staff to work with Senator Bates, the author of SB 457, her staff, and other interested parties on amending SB 457 with language that would be more in line with the language approved by the board previously, and which would get us past the roadblock we've had for 4 years now, which Ms. Sparavan is only too painfully aware of, and which would then allow the board to proceed and adopt regulations or develop regulations and hopefully adopt them that would enable this 2013 bill to finally take effect. I would like to ask the board to direct staff to work on amending SB 457 for consideration by the legislature this year. And if this is not completed this year, staff can come back to the board with this issue next year. Thank you.
Thank you, Dr. Levine. Oh, it sounds more and more complex. Any questions from the board? Dr. Hawkins.
I may have not been listening closely enough, but
Yeah,
you said
we'll
something
ask
about assess risk versus make a determination. And
Correct.
what's the difference between those two things?
So the concern on the part of ACOG was that if you are, as a physician, making a determination that a client's condition or disease would not present a risk to a home birth, and something bad happened, you're essentially liable because you have essentially determined a priori before the fact that there was that risk was unlikely. And by changing the language to assess the risks and provide an opinion as opposed to a determination, it lowers the risk of liability to the physician who is not present at the time of
Thank
the
you.
delivery.
Before I will ask for a motion, Ms. Samos, can you tell us why this became a 2-year bill? Is there, you're the only one who can give that input.
I mean, I can't, it was held in committee. I think they thought it needed more discussion. They knew that we were also suggesting language, and so it got made a 2-year bill. But I believe that Senate BMP staff has already contacted the author's office and will be holding an interested parties meeting. And so the board will be sure that we participate in those meetings.
So where was the opposition coming? For everything to become a 2-year bill, usually there is some organized opposition.
There was never a committee meeting held, so there was not organized opposition at the committee meeting, so I can't really tell you what happened behind the scenes, but I know the bill was held in Senate BMP committee, so.
Okay. Thank you, Jennifer. So can I have a motion to direct staff to direct, after the motion? Can I have a motion to direct staff to work on amending SB 457 this year? And if that doesn't occur, staff can come back on to the board with the issue the following year. We need a motion.
So moved.
Okay, second. Any further discussion from the board? Comments from the audience?
Carrie Sparrowvon, Chair of the Midwifery Advisory Council. I'd like to be sure that in your discussions to make these changes, that the scope of practice for licensed midwives doesn't change. I haven't read Bates' bill, unfortunately, because I thought it was dead, but I will go back and read it. But what I heard you say, Dr. Levine, was that it would limit our scope of practice to out-of-hospital birth and pregnancy in the postpartum period. Many, many, many licensed midwives are providing care in those interconceptional years, and we see going forward the use of more licensed midwives in community clinics and in physicians' offices, and we need to keep that scope of practice open to family planning and to hospital birth, because it's our belief that in the future we may see a system where licensed midwives can follow their lower risk clients to the hospital when those clients just need a change of venue, but their risk hasn't necessarily elevated to the point where they need physician care. So, thank you.
And you heard me correctly, and that is one of the issues that needs to be worked out in the
Yeah,
bill.
you're going to get huge opposition from the midwifery community if we change our scope of practice, especially from me. Thank you.
Thank you. Any other comments? Yes.
Hi, Rosanna Davis, licensed midwife and president of California Association of Licensed Midwives. And I'd like to inform you, yes, there was significant opposition to this bill from the midwife community and the clients that they serve. It really is a non-start for us. It completely changes our scope of practice and disallows the autonomy of the mother, the client, the family to choose a care provider. The bill is not evidence-based. It doesn't solve any existing problem. So I hope that you'll consider all of that as you take a look at it. Thank you.
Thank you. Any other comments? Comments on the phone?
No, sir, I'm showing no comments.
Thank you. So we have a motion made and seconded. So roll call, please.
Dr. Bolat?
Yes.
Judge Feinstein? Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson? Yes. Dr. Levine?
Yes.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
And Dr. Gonadev?
Aye. The motion carries. We'll now move on to agenda item 16, a presentation by the Board of Optometry and their outreach campaign. Ms. Branderwein and Ms. Sieferman. please come forward. Thank you. Thank you for here.
Thank you very much for the opportunity to be before you today. I'm Sid Brandvine, President of the California State Board of Optometry, and to my left is our Executive Officer, Jessica Sieferman. As you are aware, both of our boards has jurisdiction over the vision care services provided to the consumers in the state and an obligation to protect our Californians. I come before you on behalf of the full board, asking for your strategic partnership, an alliance, and collaboration, as together we can pursue consumer protection in the area of emerging technologies, specifically as it pertains to corrective vision care, such as and including prescriptions. There are technological and emerging technology vehicles such as online refractions and kiosks that are inside registered dispensing optician locations. And the concern is that the refraction technology and test is not a comprehensive eye exam and therefore does not address the total health of the eye. Therefore, the consumer may be missing an opportunity to truly address this, instead of the cause, only address a symptom, and therefore they're denying the ability to really get to the root of the problem. If it's not being appropriately evaluated, the condition can worsen, and then we're dealing with something more than just an eye prescription. On behalf of the board as a whole, and unanimously, I must say, we're proposing a task-based team, if we could, between our two boards, looking at such things and evaluating increased educational outreach on this matter, evaluating the potential for increased accountability and liability, as well as determine the potential to require corporations offering these services to register with the applicable licensing board, whether it's your board or our board. But together, we feel that we can make a real strong impact versus one board or the other only addressing disciplinary cases. This gives us an opportunity to be proactive instead of reactive and to partner. So I'm before you asking if you would be open to such an approach to help both boards and to take a look at what might be the best approach to address emerging technologies, because online refractions and kiosks are just the tip of the iceberg. Having just returned from London, I can see much more is coming down the path. We're seeking your support, and we look forward to the opportunity to engage and enter into further discussions. And again, looking at a small team-based approach to explore. We do not have all the answers. We're looking at an opportunity to explore this with you. Thank you.
Well, thank you both. Comments? Dr. Kraus.
I very much appreciate you and Ms. Sieferman coming to our board meeting, and we've enjoyed having Ms. Sieferman here for the full board meeting. Kim has done a great job in terms of outreach to all of the healing arts boards in the Department of Consumer Affairs. And I think we all can best serve consumer interests with more collaboration and more projects. And I would personally support a collaboration with you in exploring emerging technologies. I believe this arises out of a national concern on the part of both optometry and ophthalmology regarding online refractions and the ability of consumers to obtain prescription eyewear without having an examination by an optometrist or an ophthalmologist. And certainly the DCA and its boards are committed first and foremost to consumer protection. We also have a duty to suggest that laws are followed, but if or when laws or regulations may be antithetical to consumer protection, we might suggest new law or regulation that best serves consumers. It's all about serving consumers. Regarding the law, and I'm happy to be corrected if my understanding of the laws is inaccurate, I believe that current California law requires an optometric or physician prescription from a California licensee for the provision of other than over-the-counter sunglasses or readers. I believe the current California law requires a prescriber to be licensed in California if a prescription is filled in California or delivered to a California address. I believe California law requires a good faith examination by the prescriber. I therefore believe that it may be unlawful for spectacles to be provided in California with aid of an online refraction unless it is supplemented and endorsed by a good faith examination by an appropriate California licensee. On the other hand, I'm uncertain that the laws necessarily fully represent consumer interest. Let me explain. A headache could be the presenting symptom of hypertension, meningitis, brain aneurysm, or a brain tumor. But we don't require that when someone goes to CVS to buy Excedrin, that they be examined by a physician before they choose to self-treat their headache. So I'm uncertain that we best serve consumer interests by blocking their access to obtaining spectacles by online refraction, while at the same time, I fully endorse the wisdom and necessity of periodic eye examinations, just as I endorse the necessity of periodic physical examinations, even for those who are asymptomatic. So I'm a little bit torn asunder on this issue, because number one, I'm concerned that California law may be violated and we need to uphold the law. And number two, we don't really want to impede consumers' access to technology that provides greater benefit at lower cost, so long as there's not much risk in that process. But I would hope that we could collaborate with you on this issue and other emerging technologies. Thank you.
Thank you, Dr. Kraus. If I might just add, the public we do not want to interrupt technology. I happen to work for a technology company, so it'd be counterintuitive on my part to say as such. But there is a certain presumption by the public that when a doctor signs something or they receive a formal prescription, that there's more there, that there's something more than an output from a camera reading my eyes from either an iPad, iPhone, or other device. And it's that we want to explore to make sure that the consumer understands what a comprehensive eye exam is and what this isn't, versus taking away the opportunity for corrective lenses, because that's not what this is about.
I agree.
It's helping to detect diabetes and the cause.
Thank you. Any other comments from the board members? Okay, so I totally understand where you're coming from. I also know that technology advances, and it does put sometimes part of a profession or part of a are completely at risk. This is technological advances. What we're trying to do is consumer protection more than anything else. So we do, like Dr. Cross mentioned, we do work, especially on our staff will work with you, and they're already working with you so that we could do the best to protect the consumers. At the same time, keep the cost down. So, thank you.
Thank you all.
And any comments from the audience? You can go. Comments on the phone?
No, sir, I'm showing no comments.
Thank you. We'll go to, wonderful topic. Moving to agenda item 18, review and possible action on the draft guidelines for recommendation of cannabis for medical purposes. Dr. Cross and Ms. Lawson.
Thank you, Dr. Gananadev. Before we get into the review of the actual document, I would like to provide a little bit of background on the guidelines and the work that has gone into them. Senate Bill 643 was passed in 2015 and became effective January 1 of 2016. One of the requirements of this bill was that the medical board would consult with the California Marijuana Research Program, known as the Center for Medicinal Cannabis Research, or CMCR, to develop and adopt guidelines for the appropriate administration and use of medical cannabis. Based upon this requirement, the board established the Marijuana Task Force, which was made up of myself and Dr. Kraus. And as reported at a prior board meeting, on February 8th, 2017, the Marijuana Task Force held a meeting with interested parties to begin the development of these guidelines. The goal of this initial meeting was to begin discussion for revising the board's statement on marijuana for medical purposes. Many interested parties attended that meeting, including representatives from medical associations, state entities, telemedicine companies, physicians who recommend marijuana, and consumers. After that meeting, board staff began drafting the new guidelines for recommending marijuana for medicinal purposes, and in June, board staff met with CMCR to review and discuss a draft of these guidelines. CMCR provided extensive, valuable input based on their expertise, and a final draft document was completed by board staff and reviewed by the task force. On August 30th of this year, the Marijuana Task Force held another interested parties meeting to review the draft guidelines. At this meeting, the task force again heard from physicians who recommend marijuana, telemedicine companies, representatives from associations, and other stakeholders. Board staff took the information received from the interested parties and made amendments as necessary, and staff then provided another copy of the document to CMCR to receive their input on that draft. CMCR made some additional changes to the medicinal cannabis agreement that were based on the comments previously received. The final document was reviewed by the task force and is now provided to the members for review as part of your packets. I would like to thank the board staff, specifically Letitia Robinson, for their outstanding work on the guidelines. I would also like to thank the staff of CMCR who provided the board with expertise in this matter and assisted with these guidelines. In addition, I want to thank every licensee, organization, public entity, and everyone else who weighed in on these guidelines and provided the much needed input into the final product. The board received a number of comments on this document, and I think that the document you have in your packets shows the hard work that was put into the document. I would like to make it very clear that the document you have is just as it is entitled. It is guidelines. These guidelines are intended to provide physicians with guidance as they recommend cannabis for medical purposes. The document provides useful tools, but these guidelines are not regulations. The board does have several documents on its website that are used to assist physicians or other allied healthcare providers. All of these documents are intended to help and assist the provider. Again, the document and the attachments are intended to be used to provide guidance to physicians. There is no requirement for physicians to use the attachments provided in the guidelines. And if any physician is brought to the board's attention, the board will submit the matter to an expert reviewer, and that expert will opine on whether or not the actions of the physician deviated from the standard of care in the community. However, again, these guidelines are intended to assist physicians who recommend cannabis for patients. I would now like to turn the floor over to Ms. Kirkmeyer, who will briefly go through the guidelines, and then Dr. Kraus and I are available, of course, to answer any questions that our colleagues on the board may have. Ms. Kirkmeyer.
Thank you, Ms. Lawson. I would like to briefly walk through the document, and it's actually found under Agenda Item 18, which is on pages in the packets 18-1 to 18-9. For the most part, the board actually was able to use the Federation of State Medical Board guidelines that they had completed with a few exceptions. And it was nice because both Dr. Kraus and I had worked on the work group with the Federation to assist them in those guidelines, so we were very familiar with them. In addition, we also reviewed the board's prescribing guidelines on prescribing controlled substances for pain to see if some of the information in those guidelines could be used as well. And as you can see from the document, we did provide a preamble and a background section. And that was actually was a recommendation from our individuals at CMCR that were assisting us. We also thought that this would be important to the reader, and was also a recommendation that the board received. Then we jump right into the guidelines, and the sections relate really to the following areas. So there's an area on physician-patient relationship, including the change in law that the physician must be an attending physician, and then we include the definition of that, that title. We then have a section on patient evaluation, including the need for an appropriate prior examination with a list of what examination should include. The next section is on informed and shared decision-making, talking about the discussion on the risks and benefits. This section also includes a decision tree in the appendix, and this was something that CMCR had provided to us, and we made a few adjustments to it and then put it into the document. The guidelines then include a section on a treatment agreement. It points out that a treatment plan should include objectives and should be revisited regularly. This section also includes that written treatment agreement plan, what it should include. The next section is on qualifying conditions, which has information provided directly from the Compassionate Use Act. Ongoing monitoring and adapting the treatment plan is the next section and discusses that regular assessment needs to be completed. The next section is on consultation and referral and discusses that some patients may need to actually be referred to another specialist if necessary. The guidelines then discuss medical records, which is actually one area that's very important for physicians to understand. This section also includes information that should actually appear in the medical records, which again is our recommendation from the expert input that we have received. This section also includes a medicinal cannabis agreement that is provided as a sample in Appendix 2. And again, as Ms. Lawson stated, it is not required that this document be used, but it is a great resource for physicians who recommend marijuana to patients and gives a basis for discussion between the physician and the patient. Because California law includes a specific provision about conflicts of interest, there is a section specifically for this and includes the law from the Business and Professions Code. I do want to let the members know that we actually did receive one comment that came in outside of the board meeting that we received in writing. And it really asked us to put in the definition of what cannabis can be used for, wanted us to add epilepsy. My recommendation to the board is that we don't accept that recommendation because we were very clear in the guidelines to stick with the exact language of the Compassionate Use Act and what it said it should be used for. But also, please remember that the last phrase in the Compassionate Use Act is or any other ailment that cannabis would be helpful for. So it's a very broad definition. So it would include epilepsy in and of itself. So I would really not recommend adding one thing because then you'll get people that want to add different conditions. And I think we'd stay with what is written in the law. So with that, I'm going to hand it back to Ms. Lawson and Dr. Kraus to conclude.
I guess I would ask whether or not our colleagues have any questions. Otherwise, we'd ask for a motion to approve the guidelines and direct staff to post these guidelines on the board's website.
Dr. Lewis.
So this medicinal cannabis agreement is something that the physician can utilize, but it doesn't protect them? Is it at all, or what would be the purpose to use or not to use the agreement?
And I'm actually going to ask CMCR if they want to come forward as well, and they can provide additional information. This really was a document that they have drafted, and it's really a document that you can discuss. You can sit down. It's almost like the treatment agreement that you use when you're prescribing, that pain management agreement that you have between yourself and the patient, as a physician and the patient, when you actually recommend opioids to an individual. And it's really going over all of the concerns, all of the information that you want to be discussing with your between your physician and your patient. And I'll actually let CMCR, if you want to, Dr. Wilsey.
So we...
Please introduce yourself and
sure.
then comment. Thank you.
My name is Barth Wilsey. I work at the Center for Medicinal Cannabis Research as a cannabis researcher, and I'm here with the co-director of CMCR, Dr. Thomas Marcotte. This agreement is just to allow patients to see some of the harms that may occur. And also for to interest the patient to maybe dialogue with their physician. Only about 2% of physicians currently prescribe cannabis, so it's not very commonly prescribed. So we wanted to have a document given to the patient that might direct them to enter into more discussion with their physician at the next visit.
Dr. Cross,
Okay.
and then Dr. Lewis. Go ahead, Dr. Cross.
One of the things I appreciate is that these are not being suggested as requirements, but guidelines. And although I have never written a medical recommendation for cannabis, as I reviewed these guidelines, it seems to me to be a terrific document that I could commend to physicians to consider using, because it fully informs the patient. And there are some cases we know where complaints and litigation may follow a physician-patient interaction. So I think at the same time it documents the process of informed consent, which is appropriate to the law. So while it's not a requirement, I think it's a great service for us to provide this to physicians for their review, their own modification as they develop their own informed consent.
And,
Dr. Lewis.
yeah, and I'd also like to ask you a basic question, because it's sort of been on my mind since we've talked about marijuana. Are we the only state that calls it marijuana for medical purposes? Because everywhere else I go, it's medical marijuana. And it gets confusing because marijuana for medical purposes. Are we the only state that does that?
I think I'll defer to my colleague, Dr. Markow. We were called the Center for Medicinal Cannabis Research. I think marijuana is like a slang term, so we decided to dignify it. Or Tom, do you?
Okay.
I don't know, I assume it probably dates back to the original legislation.
Okay.
So, and just to follow up on what Dr. Wilsey said, the purpose of the agreement is really to facilitate a discussion among a broad range of physicians and patients. So some physicians may come with a lot of experience and knowledge, but some physicians may be recommending for the first time, and we really wanted to make sure there's a clear dialogue between patient and physician regarding the benefits and potential risks.
Dr. Bollard.
Yes, thank you very much. And I apologize if I'm not up to speed with everything that we have in the document. I just lost my connection and I can't follow it at the moment. But of interest to me is we have a full and unrestricted license in the state of California. So am I right to say that any physician can write for cannabis? Is that correct?
Yes.
Any
Yes.
physician, okay.
Yes.
So with that, I think I would, always my concern on the one side, and I really understand and want to learn more, and, I want to be up on this research, is the training of physicians to understand what they're doing. To give you my board members an example, and the public, I just got off of the inpatient service, and I had a patient admitted for Lewy body dementia. And with that particular diagnosis, you've got to be very careful with psychotropic medications. But in the research and looking at the pharmacy research and the drug-drug interactions, I think that we have to be really cautious and make sure that our doctors know and get the prescribed, so that we know that there's prescribing. We don't want to catch them later when something bad happens. We want to train them with prescribing now. And so I think that this research and our website really ought to reflect these areas. I know UC San Diego is a big research for cannabis, your group as well. But again, this is where people have good intentions. Doctors may have good intentions, but not understanding that this can be a potent pain reliever, can do many things. We have to understand it a little better, I think.
Yeah, Judge Feinstein, then Dr. Levine and Dr. Cross.
No, I truly hate showing my ignorance in public, but I feel the need to, and I hope if I'm under a misconception that I can be corrected. But I am under the impression that, for example, physicians who are employed by University of California medical centers are not permitted to issue medical marijuana cards as I know them to be. And I'm not quite sure how that can be or why that can be, given the current state of the law and obviously the change that is coming soon. And I would appreciate someone that has greater knowledge than I do about that, explaining to me how an entity can limit a doctor's ability to do this even under current law.
I was a physician in the pain clinic at a VA for 17 years. I could not give a recommendation for marijuana because that's a federal agency. I'm not aware of the University of California having any prohibition on my giving a recommendation for the use of marijuana, however.
Dr. Levine, I think she might have an answer, Judge Feinstein.
I
so-
believe there's a contingency attached to accepting federal funds that puts the UCs under the same restrictions as the Veterans Administration or the Naval Medical Center in Bethesda, Maryland. I'm pretty sure that that's the case. And I had just, sorry, my pedantry sometimes gets the best of me, but we don't prescribe marijuana. It's not a prescription drug, so really the correct term, as you've said, is recommend.
Right.
Recommend, not prescribe.
And that's very clear in the guidelines. It's
Yep.
a recommendation.
Yeah, I guess I would just add to Dr. Levine's point, marijuana still remains unlawful pursuant to federal law, so employers have certain restrictions on their employees about compliance with all laws, federal, state, and local.
Dr. Cross.
Dr. Lewis's query regarding marijuana for medical purposes versus medical marijuana reminds me, and my colleagues may not recall, that during U.S. prohibition, the only way to lawfully obtain alcohol was for a physician to obtain a U.S. Treasury Department issued numbered prescription pad for alcohol. And I've expressed my personal belief and hope that much of the market for marijuana for medical purposes may dry up, so to speak, as recreational marijuana becomes more easily available.
Yeah, Kim.
I just wanted to address Dr. Balot's comment on training. And so this is one that actually came up during some discussions of the interested parties meeting. And just like a doctor doing anything, it is their obligation, because they do have a full unrestricted license to practice, it is their obligation to make sure that they have the adequate training to do that and to do so competently and to follow the standard of care. The only way we could require that they have some type of training prior to doing it is if the legislation stated that they had to take that. That was the only way the board could require them to do that. But obviously, as the state medical board, we encourage physicians to receive the appropriate amount of training in addition to the training that they authorize them to get their license to be able to branch out and do the different training. And so it's something we could recommend it when we put the guidelines out, that there's, physicians may choose to get additional training prior to recommending it, but it's not anything that we could require.
Yeah, Dr. Bola.
Thank you very much. And I think that goes back to, so where do you get that training? Because right now, we've got textbooks this thick on addiction, and we worry about psychosis with people using lots of marijuana in certain age groups. So if we can link something where there are going to be resources, I think that's important, because it's not innocuous, and we have to understand its biological effect. Thank you.
Thank you, Dr. Levine.
Yeah, sorry to return to this issue, but if you look at the agreement, the word prescribed is used in the agreement. So that should be changed to recommended. And I want to applaud the crafters of this for calling out the risks to children from unintended access to cannabis. We've seen some pretty disastrous effects on young children who got into parent sources of both medicinal and recreational cannabis. And I really applaud your including in this, store the stuff in a locked cabinet.
Okay, I do want to thank both Ms. Lawson and Dr. Cross doing hard work on this one, as we've seen during the disciplinary proceedings, usually it's the very young, at very early stage in their career, residents moonlighting in marijuana clinics, or people close to retirement doing some moonlighting. They are already on the other side of the law with the corporate bar because these clinics are not owned by physicians. So that's why these guidelines are extremely important to not to make what I call as dumb mistakes, not realizing that there are California laws you got to follow. So that's why these guidelines quite a bit help. Thanks for doing that, both of you. Any comments from the audience?
And while somebody's walking up, just then with in a motion that I would like to entertain, not just to approve them, but then to also make the amendment to page 18-18, which is page 1 of the agreement on number 5, as Dr. Levine recommended, to change the word prescribed to recommended.
Yeah, we'll, as soon as the public comment is done, Kim will do that. Thanks.
Good morning, Yvonne Chung with the California Medical Association. We'd like to congratulate the board on developing these guidelines and having such an open process for soliciting stakeholder input. We had concerns about the medicinal cannabis agreement as well, including the use of the word prescribe, as Dr. Levine indicated. While we recognize that this is intended to just be a sample and it's not mandated for use, the fact that the board is putting it up with the guidelines, our concern is that physicians may just put their name on it and put it out. And if that's the case, the board may want to take a closer look at the general structure of the agreement. It's a little bit, some of the language, we can submit sort of a line by line of our concerns with the language, but I think better organization as well of sorting out, things that are side effects versus contraindications versus good practices, because the way it's sort of organized now, it's all sort of thrown together and maybe confusing for both the physician and the patient. And you may want to also, I think that the language that you use in the guidelines themselves under treatment agreement, or you specify all the items that should be in the agreement, I think that's actually really helpful, but it's a little bit hard to tie it to the agreement itself. So you may want to hold off on posting this agreement. You may also want to indicate that use of this particular agreement is optional if you do decide to go forward with posting an agreement. It doesn't really say that. It says that information that should appear in the medical record includes, and it says a signed agreement, so it could be interpreted that it should be this particular signed agreement. Some specific issues that we had with the language included, for example, on the part about pregnant women. This is actually in conflict with what ACOG has put out. ACOG has actually recommended that women who are pregnant not use cannabis. So I think, again, I think we need to probably go through this a little bit more closely to make sure it is aligned with current clinical standards. Thank you.
Thank you. Any comments, Dr. Cross? Yeah.
I would like to move that the board accept the guidelines absent the agreement, and that we do some more work on the agreement before we post it.
Okay, still further comments. We got to take a lot of any comments from the board? Comments from the audience? Yep. Dr. Ree.
Yes, hello. And I thank the board members again for tolerating my comments. This is my first visit to such a meeting, and it truly is an honor to be in front of the medical board that initially licensed me. So I thank you for allowing me to be included in these conversations. So a little more about myself. So I'm Hannah Ree, and my practice is hometown clinic and house calls. And currently I exclusively work with the elderly and disabled. And I do, all of my visits are within the homes, their businesses, the assisted living facilities, their neighbor's backyard, in the middle of a park, wherever the...
Ma'am, do you have a comment on marijuana?
Yes, yes.
Okay.
I thank you. I thank you very much for refocusing me. So, Yes, so in terms of the discussion of the medical marijuana initiative, I guess my general sense is that it may possibly actually decrease ER visits and hospitalizations, and in fact, really could decrease billings, for example, to Medicare and Medicaid. So it really would be a cost-saving measure in terms of unnecessary ER and hospitalization. But I guess my concern again goes back to I wonder if it's time in the state of California to maybe invite medical board, future medical board members who do not have hospital affiliations. I wonder if, in fact, that may help to represent those in the community who I see, the patients who are elderly and disabled. So certainly, that question has not, I don't know if it's been brought up before, or has been studied, but previously when I was discussing and I was cut off before the 3-minute talk, I do wonder if that represents an unintentional bias. So in any event, I thank the board again for tolerating my presence. Thank you.
Thank you, Dr. Ray. Any other comments from the audience? Comments on the phone?
Yes, there are two. The first one is from Dr. Garza. Your line is now open.
Go ahead, please.
Hi, this is Dr. Garza again. I just wanted to point out and request that the board take a look at Business and Profession Code 2220.05, which reflects the prioritization of investigation and prosecutorial resources of the medical board, listing repeated acts of clearly excessive recommending of cannabis as number 4 on the priority list, above sexual misconduct and practicing medicine while under the influence of drugs or alcohol. And I'm just wondering if that is maybe overlooked. It kind of reflects possibly some old-fashioned bias about marijuana.
Thank you, though. We'll look into.
Thank you.
Next one.
The next comment is from Stephen Robinson. Your line is now open.
Thank you very much. I'm Dr. Stephen Robinson, a board member of the Society of Cannabis Clinicians, and our organization represents the cohort of physicians who are most familiar with the medicinal benefits of medicinal cannabis, and we have the longest clinical experience of any cohort of physicians in the country. I'd like to applaud the board and the Marijuana Task Force for establishing these guidelines, which go a long way towards normalizing the use of cannabis for specified medical conditions. And as you know, I've made presentations to this board in the past objecting to the more strenuous and unsupported recommendations from the Federation of State Medical Boards. So I applaud the task force in not incorporating those into the guidelines. There is a number of things that I'd like to point out there that the board, I think, should take a broader view on in terms of looking at the whole context of medicinal cannabis in light of some of the epidemiologic evidence as published in the Journal of Medical Association, which point out in those states that have medicinal cannabis laws, there have been a 25% reduction in deaths due to opiate overdoses. And the previous commentator pointed out there's been tremendous reductions in Medicare expenditures for prescription medications in those states that have medicinal cannabis laws on the books. I think part of the reluctance and discomfort with medicinal cannabis arises from the lack of training received in medical school or in residency regarding the pervasive influence of the endocannabinoid system, which we must remember has only been discovered as a very extensive physiologic system that exists not only in humans and other primates, but in the animal kingdom all the way down to invertebrates. And this dearth of training has been recently documented in an article by the chair of psychiatry at Washington University Medical School. And I'd be glad to forward that to the task force and the board, where she has actually spoken to deans of medical schools and residency program directors about the dearth of any kind of training or familiarity in these programs, exposing their trainees to medicinal cannabis. And I would hope that the board would find some way to help resolve that discrepancy. In terms of the guidelines in particular,
Please conclude.
I make a note that the
Dr. Robinson?
Decision tree should be modified to be more in line with the existing guidelines of the medical board. They have already stated that the medical board guidelines do not require patients to fail on standard therapy before medicinal cannabis is recommended. And the decision tree should be modified to...
Excuse me. I'm sorry, you are out of time. You do need to conclude.
Thank you, Dr. Robinson. Who else is on the phone? Any other comments?
Are there any other comments on the line?
I'm showing no further comments at this time.
Thank you. Dr. Cross, can you repeat your motion, please?
Move for the board to accept and publish the guidelines with the exception of the agreement, which we will continue to evaluate and amend.
Okay, so the motion was made, seconded. Any further? Yeah. Any further comments from the board? If not, roll call, please.
Dr. Bolat?
Yes.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Dr. Levine?
Yes.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
And Dr. Gonadev?
Aye, and the motion carries. Boy, it's Jennifer's time.
Dr. Gonadev, can I just ask one question? Does it make sense for us to provide some direction as to staff with respect to working on this agreement as to when we either want to see it back or who should be working on it? I'm happy to work with Dr. Kraus and Kim and Carrie and continue to do that, but
Yeah, it's unfinished item, so we expect the task force to continue to work with.
okay, thank you.
Thank you. Jennifer, turbo speed, please.
Okay, so please turn to tab 19 in your legislative, or in your board packets. So the 2017 legislative session has ended, and the legislature does not reconvene until January 3rd, 2018. The governor has taken action on all bills we have taken positions on that are not two-year bills. This is the first year of a two-year session, so if a bill did not pass this year, it can always come back next year. Please turn to your tracker list tab. The bills in green are bills that the board has taken positions on and that have been signed into law, and the one bill in orange was vetoed by the governor. I will only be giving a brief summary of each bill and then discussing the board's implementation plan. If any members have questions on the specifics of the bill, please let me know. Of note, every implementation plan includes a newsletter article in the board's winter newsletter and notifying and/or training board staff, DCA's Health Quality Investigation Unit staff, and the Attorney General's office. So I'll not mention those items, but please know they are included in the implementation plans for all of our bills. So the first bill is AB 40, Santiago. So this is the bill that requires the Department of Justice to make electronic prescription drug records contained in cures accessible through integration with the Health Information Technology System, beginning no later than October 2018 if that system meets certain information security and patient privacy requirements. The board's implementation plan is to include a standalone article in the newsletter and to update the board's website regarding cures, and then to send an email blast to all physicians before the bill becomes effective on October 1st, 2018. If no members have questions, I can move on to the next bill.
Next.
Okay. The next bill, AB 443 Solace, this is the bill that expands the scope of practice for optometrists to include the ability to provide habilitative services, provide for more independent practice, perform additional procedures, and administer vaccines. The board's implementation plan on this one is only to do the usual newsletter article and notification to staff, DCA, and the AG's office. Do any members have questions?
Nope.
Nope. Okay, AB 715 Wood, this bill was actually vetoed, and a copy of the bill and the governor's veto message are in your packets. The next bill, AB 1048 Arambula, this is the bill that beginning July 1st, 2018, authorizes a pharmacist to dispense opioids as partial fills if requested by the prescriber or patient. This bill also removes the requirement that pain be assessed at the same time as vital signs. The board's implementation plan is the usual newsletter article and notification to staff, DCA, and the AG's office. Any questions?
Keep going.
I'll just keep moving on
Unless we stop, you keep going, yeah.
Okay, so AB 1340 Mainshine allows for an optional CME or continuing medical education course in integrating mental and physical health care in primary care settings, especially as it pertains to early identification of mental health issues and exposure to trauma in children and young adults and their appropriate care and treatment. The board's implementation plan is to include a standalone article on this type of CME in the newsletter. Next bill, SB 241 Monning. This is the bill that revises the existing law regarding the rights of patients to access and copy their medical records. And this is the one that made it more in line with HIPAA. The board's implementation plan is to update the board's website regarding patients' access to medical records and the frequently asked questions that are currently on there on the board's website. Okay. Next bill is SB 512 Hernandez. This is the bill that requires a healthcare practitioner that performs a stem cell therapy not approved by the United States Food and Drug Administration to communicate this to his or her patients on a notice displayed in his or her office. This bill also requires the medical board to report citations issued and discipline imposed with regard to licensees who provide these stem cell therapies in its annual report, and that reporting would begin with the board's 2018-19 annual report. So the board's implementation plan for this bill is to create an allegation and violation code in Breeze in order so we can track those citations issued and discipline imposed, and report all discipline and citations in the board's annual report. Any questions? Okay.
No, I think this is, at this stage, this is extremely important.
Right.
There are so many of these stem cell clinics popping up with unapproved treatment, so.
Right, and this, I did talk to the author's office after our board had significant discussion at the last meeting and kind of told them the board's discussion, and we thought maybe it didn't go far enough, and they understood, but this was kind of just a first step in that direction, so. Okay, the next bill, SB 796, this is a sunset bill for some of the other boards, but the portion that the board took a position on is the portion that requires the Department of Consumer Affairs Substance Abuse Coordination Committee to review the existing criteria for Uniform Standard Number 4, which is regarding substance testing. So the board only took a position on that provision, and so our implementation plan is to participate in the review of that Uniform Standard Number 4 criteria, and if it ends up being revised, the board will need to update its uniform standards regulations.
Can you explain that one again?
Yeah, so that's the one where it was actually the sunset bill for the naturopathic board and I think another, and the respiratory care board, but it had that one section that said that the DCA had to reconvene the committee that did the uniform standards and take a look at Uniform Standard Number 4 because they believed that emerging technologies had maybe changed that testing and that they need to look at it again and review it, and if changes are needed, that they will make changes to that uniform standard, just that particular one Uniform Standard Number 4.
Okay.
Okay. And so that brings us to our sunset bill, our last bill that we're all so happy got signed. So I can if you would like, I can go through the sunset bill and what got included. I mean, we know that there's, we're extended until January 1st, 2022. There is a signing message, which is in your packets, that basically, let's see here. The signing message says 2 issues were identified during the legislative process requiring further review: vertical enforcement and the exchange of expert witness reports between a doctor under investigation and the medical board. And the governor directed his staff to work with the legislature and the attorney general's office to determine what changes are needed. So board staff will actively be working on those issues. There's a 1-year sunset date in our bill for vertical enforcement. So staff will be working on it. And I know we talked about this a little bit yesterday with board members. We'll be attending those meetings and participating. So I don't know if you would like me to go through what got included in SB 798.
Just very brief summary. This is our bill, so.
Yeah, right. Okay. Okay, so the things that actually got included, so the 2-year license issue, going from birth date to a straight 2-year license, that language is included. The postgraduate training, we talked about this a little bit yesterday, changing it from 1 or 2 years to a 3-year requirement and doing away with the requirement that we approve international medical schools. That's a quick summary of that. The adverse event reporting language for outpatient settings, revising that, what needs to be reported to the board, that was included. Let's see, the posting of the notice to consumers language was included to allow the board to revise that posting through the regulatory process to make it more consumer friendly. Allowing the board to fine for failure to submit a 805.01 report to the board, that is included in this. Allowing the board, 2 members to be appointed by the board to the Health Professions Education Foundation, that was included in this. Doing away with the requirement that the board approve non-ABMS specialty boards, the board will no longer have that. It's effective January 1st, 2019. Making technical changes to make it clear that the Board of Podiatric Medicine is its own board, that language was included. I'm just gonna kind of do like the higher level ones. Sorry, I have a tickle in my throat. Okay, like we mentioned, the expert witness report language, that's actually in there, but we're going to be working on it this year. And I think there's some like deleting of outdated sections, but that's the main crux of what got included in our bill. Is there any questions?
Yeah, board members, any comments, questions? Okay, any comments from the audience? Comments on the phone?
Well, I need to go over our implementation plan really fast though first. So.
Okay. Why not?
Okay, so there's this is the longest one. So we're going to work on strategic communication and outreach to licensees and interested parties on changes to law, effective dates, and updates to the board's website and pretty much all areas and programs. Newsletter articles on all of the changes, including postgraduate training, international medical school, the new adverse event reporting requirements, etc. Notifying board staff, DCA, AG's office staff, revise existing regulations on the notice to consumers posting to include the new requirements and notify physicians of the change. Submit breeze changes for the 2-year license that begins July 1st, 2018. We're going to work on developing procedures for appointing 2 medical board members to the Health Professions Education Foundation. And we hope to appoint those 2 members at the January 2018 board meeting. And for the 805.01 fines, the board will work with the California Department of Public Health to draft an all-facility letter that can be distributed to health facilities. And for the postgraduate training changes, we're going to conduct outreach to the graduate medical education programs, develop and revise the application forms, and submit needed changes to Breeze. So that concludes that portion.
Kim?
And I would like to add on the HPEF, if anybody is interested in that, to please let us know so we can go through the process when we come to the January meeting, okay?
Okay, Jennifer, are you done with the item A?
I am.
Okay, so again, any comments from the board? Comments from the audience? Comments on the phone?
Yes, there is one from Eric Andrist. Your line is now open.
Go ahead, Mr. Andrist.
I'd like the board's members to consider this. There was recently a bill before the legislature, SB 1479, that dealt with harsher penalties for government agencies that break the Public Records Act. That bill was never put on the agenda to be brought before the board, even though this board gets a plethora of Public Record Act requests. And I've been bringing up problems with Carrie Webb breaking the Public Records Act for over a year. One would think that that would have been an important bill for this board to talk about, but it was suspiciously missing from every agenda since that bill was presented. Each of the board members should really wonder about the flow of information that is or isn't brought to them. While the governor vetoed this particular bill, he wrote that he is, and I quote, open to future discussions about strengthening public record disclosures for all branches of California government. So while the governor wants to strengthen it, the medical board is trying to sweep Carrie's illegal activities under the rug. You're all good at patting yourselves on the back for everything. Are any of you brave enough to step up and call each other on things that are done wrong, or will you just be sheep and sit there on your hands, especially the non-doctor members who rarely say anything at all? Speaking of which, why is there never a patient safety advocate on the medical board? And Dr. Ree should be allowed to say what she wanted to earlier, since Carrie wrongly prevented her free speech. Thank you.
Thank you. Any other comments on the phone?
I'm showing no further comments.
Ms. Amos, item B, legislative proposals.
Okay, so we don't have too many this year because a lot got taken care of in our sunset
Thank
report.
you so much.
But the first one, the UCLA IMG program, and you may remember last year we kind of brought this to the board thinking that it might be a proposal for last year, and it didn't end up going through, and Dr. Bullock gave a presentation on this program. But I'll just give a quick overview. So existing law allows participants in the UCLA International Medical Graduate Program to obtain hands-on clinical training. This bill, the bill allowing for the hands-on clinical training was co-sponsored by the Medical Board of California and the UC Office of the President in 2012. The law requires UC to prepare a report by January 1st, 2018, and would sunset the provisions that allow the hands-on clinical training on January 1st, 2019. So we have to go through with legislation this year to extend that. The board would like to co-sponsor a bill with the UC Office of the President to continue the program permanently, which means what board staff is proposing is just taking out that sunset date and allowing that hands-on clinical training to be included. The UC Office of the President is currently going through their approval process for this legislation, but we don't anticipate any problems, and I've already talked to them, and they're looking forward to working on this year. Also, there's some little technical changes that will need to be made to the portions of law that refer to some sections that are going to be deleted as a result of our postgraduate training changes. So we just need some technical changes there, but we're basically requesting approval to go forward with that change this year.
Are you asking for us to have a motion,
Yes.
Jennifer? Okay. Any comments on the board? Okay, what exactly you want the motion as?
To approve the board staff to go forward and co-sponsor a bill with the UC Office of the President to remove the sunset date for the UCLA IMG program, the portion that allows for hands-on clinical training.
Okay, can I have a motion?
So move.
Okay.
Second.
Okay, any further comments? I can make a comment. It's a great program. Actually, it gives many minority doctors coming from other countries a chance to do residency. And they go into minority communities, and it's wonderful. So, any comments from the audience? Come on in. Dr. Ree.
Yes, hello. Thank you again for letting me speak. So it's wonderful, and I agree with you, sir, that it's wonderful to see that physicians from other countries or minority physicians are certainly welcome to have an opportunity. I guess my concern is once they're licensed, if there may be an unintentional bias in cases which are pursued by the board. And then also, secondly, so I thank you again. And then earlier, she had mentioned this 805 report from hospitals, the mandatory reporting about a physician, that kind of thing. And so I wonder if perhaps, again, it may be time for California and our patients to see medical board members who do not have the hospital affiliations. I wonder if perhaps there are physicians who may have a different perspective and who may have a different type of background, who certainly are interested in patient care and maintaining medical standards, but that do not have the hospital affiliations. I wonder if it's time to have those types of individuals on the medical board, because we certainly use them as, for example, expert witnesses and in other capacity. So I thank you again.
Thank you, Dr. Ree. Any other comments from the audience? Comments on the phone?
I'm showing no comments.
So motion was made, seconded. Roll call, please.
Dr. Bolat?
Yes.
Judge Feinstein? Yes. Dr. Hawkins?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson? Yes. Dr. Levine?
Yes.
Dr. Lewis?
Aye.
Ms. Pines?
Yes.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Yes.
And Dr. Gonadev?
Aye. Motion carries.
Okay.
19C,
No,
status
we're
of
still on B because I have a couple omnibus proposals, so I wanted to separate them.
Keep going, Jennifer,
Okay,
yes.
So the omnibus are technical changes, basically we think can be put into the committee's omnibus bill, just technical changes that staff has identified that are needed. So the first one is amending Business and Profession Code, Section 801.01, to require reporting entities to submit supporting documents for all case types instead of only for judgments and arbitrations awards. And this will allow staff to confirm the case type is being reported correctly and to ensure public disclosure is being reported accurately. Should I just go through the three of them and then we can vote them all at the same time?
Yeah, can you explain that in English so that we can?
Maybe, I think I'll have Carrie maybe help me out with this one.
Okay.
Sure. So there are certain things that are posted on our website according to Business and Professions Code, Section 2027. And arbitration awards and judgments are posted, but settlements are not posted unless there's a certain number within a certain period of time. And our concern is that some arbitration awards or judgments are being reported as settlements, in which case they wouldn't be posted, but they should be. And if there is supporting documents required to demonstrate that that the board is being informed correctly, then it can be verified.
Okay.
And I think it might just be actually an oversight in the drafting because it's required to provide that documentation for the judgments and arbitration awards, but not for the settlement. So it's inconsistent as well.
Okay, keep going.
Okay, the next one is to delete Business and Profession Code Section 2424 Subdivision C that allows the renewal of any expired physicians and surgeons or podiatrist license within 6 months from its date of expiration to be retroactive to the date of expiration of that license. This section of statute staff believes is outdated. Renewals are now timely and can be done online, so there's really no need to allow for extra time for renewal and to allow a physician to potentially practice for 6 months with an expired license. So it's a section of code that was probably put in there when we had a long wait time for renewals, and that's not the case anymore. And we tried to do a little research, but it was put into the law a long time ago, so we would have had to hit the archive. So that's that. Is there any questions on that one?
So if someone retires and wants to renew a license, is there a timeline where it is considered a new license application, or is it just a renewal? My concern is that if somebody doesn't practice for 2, 3, 4 years and wants to be a doctor again, it's not that simple, so I'm just curious.
So if an individual goes into retirement, they still get a renewal notice and they still renew and they still go through the process. There's no problem with that. What this law specifically says is that an individual who doesn't renew within 6 months afterwards, if they do renew during that 6-month time period, it's as if they never were delinquent during that time frame. So it's not really anything to do with anybody that's in retirement.
Okay.
Okay, and the next one is related to a section of the labor code, and so this is 139.2, and it has to do with workers' compensation, correct? Yeah. And it requires that the qualified medical evaluator must have qualifications that the administrative director of workers' compensation and either the Medical Board of California or the Osteopathic Medical Board of California both deemed to be equivalent to board certification and a specialty. We think this is something that we've kind of been asked to provide that information. This is not something we do. We don't deem equivalency for board certification for the Division of Workers' Compensation, so we believe this section should be deleted. Is there any questions on that?
Kim, can you?
So there.
How did it even come about? I'm just curious.
No idea. How did it come up to us? It came up because we actually received a letter from a doctor who was trying to become a qualified medical expert for workers' comp, and they wrote to us and said, we need you to prove that we're equivalent to being board certified. And so we said, well, we don't do that. And then we looked at the law, and the law says, well, you can't get this unless the board does do that. And that's not something that we can't say, okay, we are going to look at all your training and we think you're the same as board certified. And so it's an obscure law. It looks like, Carrie and I have really looked at it. It looks like it's something that was, again, written a long time ago. And it also says that the workers' comp director has to say that they're equivalent. And I don't even think they even have the knowledge to do that. And so we just want to remove it and say if the individual's board certified, then that fits into the requirement of the law. So it's, again, one of those laws that just come in, and we've had two individuals, maybe if it was one, we wouldn't, but now we've had another individual contact us, and I don't know if it's because workers' comp went back and said, okay, all of you individuals who are those QMEs, you need to submit documentation and prove how you meet the law, and so now they're catching some of these individuals that might not have met the requirements before. That's an assumption on my part, but it was just something as we went through, we thought this is not good law, so we wanted to change it.
Dr. Bola.
This may seem like a very naive question, but let me ask it anyway. For the physicians, that are working with injured workers, they hold a California license and they're regulated by the medical board. Am I right or no?
MDs.
They don't have
MDs
to
are.
hold a California license, though, correct?
We have, I think it's workers' comp that actually does not have to have.
That's correct.
A California license. I know that there's two different ones. Department of Insurance is one, and workers' comp.
That is stunning to me, but I will, maybe that would be something worth looking at.
So it has been, I do want to let you know, and it has been looked at the past, and I know that this is actually something that the California Medical Association has brought to the board's attention at public board meetings as well. We did a presentation on it. Carrie researched the whole issue. Legislation has been put in the past, and it was vetoed to try to get it to where they had to be California licensees.
We did support any piece of legislation that came through,
Right.
so.
Right, and we put out on our website that it is the practice of medicine, because that way when we get complaints, that, we look at those to make sure that the individual's following the standard of care when they provide those evaluations. So we have said it's the practice of medicine, it's something we should investigate, but there is no requirement that the individual actually be licensed in California.
I think I might understand the distinction, because a QME or an AME may be doing a function within the injured workers, whereas the primary treating physicians may be licensed in the state of California, right? Because they may have injured workers and they may have others, but it's just interesting, and I would hope that
The
we would look at
utilization
that.
review piece.
Right,
of
that's
that.
what,
Well,
I'm
it's
sorry,
the
that's
UR.
what- Yeah, you're right, it's
the-
utilization review, yes.
Right.
That's the one.
Okay, thank you.
I think we may be talking about two different
I think so.
things.
Okay, just a question, Jennifer. Why didn't we get that in the sunset bill about the UR doctors who do and work for the insurance companies and deny the injured workers the appropriate treatments? Why shouldn't they have California license?
I think we didn't include it in sunset review because there's been so many pieces of legislation that have been either vetoed or not, or we've supported it, that no one really has. Authors seem to not want to bring that issue forward again. I mean, I think we've publicly said at board meetings that we believe utilization review is a practice of medicine, but we didn't include it in sunset for that reason.
Okay, I am just curious. Dr. Cross.
I'd like to inquire if we receive a complaint about a physician's behavior and find out that we have limited authority because that physician does not have a California license, can we forward that complaint to the state board that does oversee them?
The issue is that it's not illegal under current law for workers' comp and insurance to use physicians not licensed in California to do utilization review. There would have to be a legislative change for a report to be acted upon.
Yeah, my question is not so much whether or not the act was lawful, but if there's a complaint about the behavior of that physician, but we have no authority over that physician who's not California licensed, can we forward that complaint to the board that has issued their license?
Yes.
Thank you.
The problem they're gonna run into is the same one we run into in other states, is that they may not have the authority to subpoena those medical records and get them.
That's true.
Because it's across state lines.
It's unfortunately, it's sad that injured workers cannot get the appropriate care because of some of these, not all, some of these UR-docs. So, Dr. Levine.
Just a question, do the physicians who do independent medical review for appealed services or denial of services, IMR, are they required to have a California license?
Not only are they not required to have a California license, but they don't have to put their names on it.
A source of great concern.
Yes, it is, very much.
One more question or point?
Yes, Dr. Cross.
Kim, if you think it's worthwhile, this might be a subject to discuss at the FSMB. I'm sure we're not the only state that suffers with it.
Okay. Anything else, Jennifer?
So those are the three technical proposals that we would like to have approval to move forward with within an omnibus bill authored by the Senate Business and Professions Committee. So I need a motion to approve those.
So moved.
Three.
Okay, do we have a second?
Second.
Any further discussion from the board? Comments from the audience? Yvonne?
Good morning, Yvonne Chung with the California Medical Association. We had some comments on the omnibus proposals. On the amendment related to requiring reporting entities to report supporting documents for all kinds of medical malpractice case types, we were a little bit confused, and I think we'll have to see what the language is. If this amendment proposes to actually expand the types of malpractice cases that are posted, or that gives the medical board additional authority to determine what is a settlement and what is not, we would have some concerns about that being part of an omnibus bill, and would recommend that that be taken up as a separate bill. On the issue of the expired physician surgeons licenses and their renewals, we regularly get calls about physicians who, I think this is just the reality of the world, physicians renew at the last minute, and this question comes up a lot. I think that we would want to retain some flexibility for physicians so that they do not, if they're 2 weeks late renewing their license, certainly we don't want them practicing while their license has expired, but we also don't believe they need to go through an entirely new application process if they miss a deadline by a certain time frame. So we would recommend that the board consider flexibility for those renewals. On the issue of the QMEs and determining board equivalency, we understand the board's problem, especially in light of SB 798, which basically said the board did not have the authority to determine equivalency with regard to board certification. However, it does leave that thorny problem of that if the board is removed, it leaves only the administrative director of the Department of Workers' Compensation, who we agree probably does not have the training or experience to determine board equivalency. So I think that in determining the solution to that, one, it may not be appropriate for omnibus, and two, there may be a larger discussion that needs to happen there, that if the board is not going to be determining board equivalency, we also want to make sure that other entities with even less training experience are placed in that position of making that determination. Thank you.
Thank you. Do you have any comments, Jennifer?
I mean, so depending on if there's major concerns with these, they may not be omnibus, so we might have to look for a standalone bill, just depending. I think for the first one, for those concerns, we don't agree that it's expanding. For the second one regarding the renewal, I believe there's already some flexibility, and Kim?
They would not have to submit a whole new application. They would just continue through the renewal process. It's just that they're delinquent, so there would be no new application.
Most important thing is, though, they cannot practice medicine.
So, I mean, I think we can work some of those issues out, and we'll just have to see if these are controversial. Kind of the process is we submit what we think is omnibus to the Senate Business and Professions Committee. They run it through the powers that be, and then they approve it or not, and then we just kind of go through the legislative process, so.
So on the board equivalency, my understanding is we left it to the ACGME as the national board for the MDs. ABMS.
Right.
So ABMS to be the agency which gives board equivalency, not any state agencies, which we took ourselves out.
Right, and that was specifically for, in our section of that was for advertising purposes. This is related to workers' compensation, which is never something that we've really done until we got those 2 inquiries that made us aware of this section of law, so.
Okay. Any other comments from the audience? Oh, Dr. Levine.
Yeah, just to Ms. Chung's comment, if we've never done this and we don't do it and we never anticipate doing it, removing this language doesn't lessen any protection.
Right.
It just removes a section of language that's never been operative and never will be operative. So it doesn't confer additional authority to the administrator.
Okay. Any other comments from the audience? Comments on the phone?
Yes, there is one from Eric Andrus. Your line is now open.
Go ahead, Mr. Andrist.
Just a reminder that California has over 100,000 doctors in it. Los Angeles alone has over 39,000 doctors in it. And the CMA's membership is only about 43,000. So they do not represent the majority of doctors in California. So just keep that in mind when the CMA speaks. Thank you.
Thank you, Mr. Andrist. Any other comments?
I'm showing no further comments.
Okay. Do we have a motion, right? Okay, so we have a motion, seconded. Can we call for roll call, please?
Dr. Bolat?
Yes.
Judge Feinstein? Aye. Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson? Yes. Dr. Levine?
Yes?
Dr. Lewis? Aye. Ms. Pines?
Yes.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Yes.
And Dr. Gonadev?
Aye, and the motion carries. Now you ready, Mr. Mose, for regulatory actions?
Yes, 19C is the matrix of regulatory actions. You can see the status of all of our pending regulations. You can find that at BRD 19C-1. So I'm just here, you should have an updated matrix that was passed around. If it wasn't, I can tell you the only thing that got updated was the current status of the physicians on probation regulations. It was filed with the Secretary of State on 10/10/17. That was the only update. So I'm just here to answer any questions that members may have on that matrix.
Any questions from the board? This is the one-page document talking, right? Okay. Yeah. Okay. Any comments from the audience? Comments on the phone?
Showing no comments.
Thank you. This doesn't need any approval.
No.
I gather. Okay. Go ahead, please, continue.
Okay, 19D, the last item. This is federal regulations. The Department of Veterans Affairs is have some proposed telehealth regulations that are open for comment right now. And these proposed regulations would allow Veterans Affairs healthcare providers to provide care to Veterans Affairs patients through the use of telehealth, notwithstanding any state laws, rules, or licensure, registration, or certification requirements. And this means that VA physicians would have the authority to treat veterans via telehealth or telemedicine, regardless of where the patient is located. So this would override the laws in California that require physicians who treat patients in California to be licensed in California. This would only apply to Veterans Affairs physicians providing care to veterans. In the past, we've brought in similar federal law, proposed laws, and basically we've always taken the stance that if a physician is treating a patient in California, they should be licensed in California. So what we're asking for is to approve staff to submit comments on these proposed regulations that basically oppose allowing Veterans Affairs physicians to not have to meet their licensure requirements in California.
So moved.
Do we have a second? So, Jennifer, so the doctors who practice in California VA hospitals, my understanding is they don't need to have California license. Is that correct? Or Carrie?
They have to practice within the VA facility.
Right, right.
So this would expand it to any
So this
patient.
expands to all the veterans, not just practicing in VA hospitals.
And via telehealth.
Yeah, it's VA telehealth.
Right.
Interesting. Okay. Any other comments? Yeah, Ron.
Is there a downside? They've been doing this for years. We don't require a license in California. They have to have a state license.
Well, they haven't been providing telehealth, though. That's the difference. So now if it's in a VA facility, now it would allow telehealth to any veteran in California. So it's came to our attention. In the past, we've taken that stance. So, I mean, we don't have to provide comments opposing this, but staff thought it was along the lines of similar comments we've provided in the past.
Dr. Cross.
I believe that we should stand in opposition because that's consistent with our opinion in the protection of California consumers, that the doctors who prescribe for them should be California licensees. Not everything that the federal government asks for or legislates is necessarily in the best interest of Californians, and I think we're obligated to serve California consumers in opposition to that.
That's good, Howard. You're talking about states' rights. So, so I appreciate that. Actually, it is the California Consumer Protection, even though I take it for granted in the end, federal government do what they think is the right thing to do. They are providing the VA care, and they might, but I think we should take make opposed comments.
Yes, I agree that we should take an opposed comment. And the other thing is, have you heard anything about Indian Health? Because in a way, there's a little similarity because those physicians are not required to have a California license either.
I think there's a little confusion going on. So this is actually for any VA patient. So let me just give you an example. So the VA, if I go to the VA building, the VA hospital, I'm a VA, I go to the VA hospital, that individual there does not have to be licensed, but they're still under the auspices of VA and they're there. I'm at home or I go to a clinic somewhere, I'm a VA patient that's not within the VA administration hospital, but I go there, they could actually telehealth to someone that's licensed in Texas and provide care to me, and they don't have to be licensed, which is outside. So that's why we're saying, so it is different than what's allowed right now under the federal law.
That's very helpful, that example.
Okay.
Right. So that person doesn't have, the doctor in Texas doesn't have to be a VA licensee or has to be a VA licensee?
He'd probably have to still be a VA licensee, he'd probably have to still be a provider, just like a Medi-Cal, Medicare providers are having that, but it's just, there's no oversight over this individual, he's coming straight from Texas. Is that correct, Carrie, in that?
Well, it's just
description?
like the eyeglasses, the technology keeps moving. So, so any comments from the audience? Comments on the phone?
Yes, there is one from Dr. Garza. Your line is now open.
Go ahead, please. Just like the eyeglasses, the technology keeps moving. That's me. So any comments from the audience?
Can you please turn down your webcast?
Oh, it's delayed.
Dr. Garza, if you're there, your line is now open.
I think that I'm wondering if the board is considering that it might be removing some of the rights of those veterans when it enacts something like this. Just something to think about. I also wanted to comment on Section 1358, Physicians on Probation. The language which states that physicians on probation
Dr. Garza, what agenda item are you speaking on?
it's physicians on probation, Section 1358, and the language suggests, or the language indicates that every physician on probation shall be drug screened. And I don't think that is what is in practice right now, according to the medical board probationary practice. I think that that word shall should be changed to may, because drug screening every physician on probation is not constitutional unless there is a nexus between the discipline, the act which requires discipline, and the probation requirements. Not every physician on probation has a problem with drug or alcohol, so it would be unconstitutional to drug screen all physicians on probation. So I'm requesting that the language be changed from shall to may. Thank you.
Thank you. Any other comments on the phone?
I'm showing no further comments.
Okay. So we have a motion, right? Do we have a no? Yeah, okay. I think time and hunger are getting to me. So roll call, please.
Dr. Bolat?
Yes.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson? Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Aye.
Ms. Sutton Wills?
Yes.
Mr. Warmoth?
Aye.
And Dr. Gonadev?
Aye, and the motion carries. Thank you, Ms. Samos. Now I'd like to go to agenda item 20, Vertical Enforcement Program update from HUIS, Ms. Castro.
Good morning. HQE continues to work collegially with the Health Quality Investigation Unit in addressing vertical enforcement cases and clearing a record amount of transmittals of cases to our office for prosecution, as well as closures of investigations and other action. We're looking forward to meeting with Dr. Yip for the second time to continue to collaborate concerning issues in our work group with respect to vertical enforcement. That includes addressing workflows, prioritization of cases and procedures. And the Health Quality Enforcement section firmly believes that a hands-on board member activity is important to foster leadership and understanding of the vertical enforcement program, the burdens that are placed on the staff performing these important functions on your behalf, and also to allow the board to understand the value that is added to the enforcement process by the joint investigation of vertical enforcement cases. From time to time, we do meet as well with Ms. Delp on an as-needed basis on case dispositions and any other issues that she brings to our attention. We continue to enjoy working with Ms. Nichols, and she and I meet on a monthly basis and as needed to also collaborate and troubleshoot. Our Attorney General, Javier Becerra, is
extremely engaged in all of our client services that we provide to the Department of Consumer Affairs, including the medical board. And he is very, very exceedingly interested in protecting patients and enhancing the health quality in California for patients and for consumer protection. And with that, that concludes my vertical enforcement report.
Thank you, Ms. Castro. Any questions to Ms. Castro? Any comments from the audience? Comments on the phone?
Showing no comment.
1 second. Please come in. Whoever, Dr. Ree. Yeah, go ahead.
Yes, I thank you again for your patience and allowing me to respond. I guess as far as the goals of being consumer protection and other statements that were made, I guess just as a clinician and having gone through the process of medical education, it would just be maybe of benefit. I'm wondering if perhaps a retrospective study, a data analysis on whether certain decisions or actions or cases which are pursued are in fact quantitatively protecting consumers such as the elderly and disabled. That would be my kind of main point. And I apologize for the stuttering, that this is not easy, of course. So I thank you again. It's just maybe a few retrospective studies. So thank you.
Thank you. Any comments on the phone?
Yes, there is one from Eric Andrist. Your line is now open.
Go ahead, Mr. Andrist.
I was hoping Ms. Castro could clarify something for me. How long does it take once the Attorney General's office and a doctor agree to a stipulated agreement before the Attorney General's office sends that back to the medical board?
Would you like me to respond to that?
It's your.
Yes. Our performance marker for performing that function, which I understood from Mr. Andritz's question to be how long does it take the Attorney General from the time it sends the stipulation to the client to the time that the client adopts it? Is that what he asked?
No, from the time that the doctor and the Attorney General's office agree to a stipulated agreement and the time that the Attorney General's office sends it back to the medical board to process.
Got it. So the question is, you're asking how long does it take the Attorney General from the time the respondent and his or her attorney sign off on a proposed stipulation to when we send it to the medical board for consideration of adopting the stipulation? I think that's the question. Our performance marker for that is to turn that letter around within 30 days to this board for their consideration of the stipulation and the agreements that we have reached with respondent and opposing counsel under the obvious leadership of Ms. Kirchmeier and our legal staff. So 30 days, and there will be more information for the public in the future through Business and Professions Code Section 312.2, which will be published in January 1st, 2018 for all clients for DCA.
Thank you, Ms. Castro. Any other comments on the phone?
Showing no further comments at this time.
Thank you. Thank you, Ms. Castro. Now it's item 21, update on Attorney General's office.
Yes, it's my pleasure to report to you that there's no significant litigation to report to you at this point. But I am very sad to report that two of our most valued Deputy Attorney Generals will be retiring. We wish them very well in their future retirement activities. Our Brenda Reyes, who has been with the Health Quality Enforcement Section since 1999, but with state service for 35 years, she'll be retiring from our San Francisco office. So we're very sad to see her go through her career. She did have a lot of published cases and a lot of sex misconduct cases that she handled very adeptly for this board. She was also a very good source of mentorship for a lot of our newer staff.
Additionally, I'm sad to report that Lori Fercucci, one of our Deputy Attorney Generals in San Diego, will also be retiring. She retires with 12 years of DOJ practice, 7 years with the Health Quality Enforcement Section, after a long and illustrious career with the state and also on behalf of medical insurance companies. And so we're very sad to see her go. She has provided a very strong oar to all of our client liaisons, including the medical board. And she always had a very good heart and very keen eye to policies and procedures. So I will miss both of them very much. And I know that they really, really enjoyed working for this board. And with that, that concludes my Attorney General report.
Thank you, Ms. Castro. I just want to again emphasize that this board's intent was never to eliminate vertical enforcement. It is to streamline the vertical enforcement so that we can really shorten the time it takes to really go through. And with the governor's office help, this board, along with the DCA and the AG's office, we will come up with what the governor is asking us to do. So just want to assure you that our goal is to work together, not against each other.
I will communicate that sentiment back to the Attorney General and his staff.
Thank you. Any questions from any comments or questions from the board? Any comments from the audience? Comments on the phone? Yeah, oh, one. Okay, come on in, please.
And while she's walking forward, please just send our best to the two individuals retiring. I've worked with Ms. Reyes for as long as I've been with the board, and Lori has just been a ray of sunshine, I have to tell you. So I'm very sad to see them go.
Thank you, Ms. Kirchmeier. I will let them know.
So I first of all want to thank, of course, the California Attorney General's office for their work and with the medical board, that kind of thing. I guess I would, and certainly I can only speak from experience, but I would just maybe encourage those on the Attorney General's office to be aware of cultural diversity amongst providers. That certainly for providers, we have a certain language that we speak and that sort of thing. But in terms of using terms such as OG, I just would encourage the Attorney General's office to be aware and cognizant of cultural diversity amongst physicians and languages, and not necessarily foreign languages, but diverse languages that we speak within the English language. Thank you.
Thank you, Dr. Ree. Any comments on the phone?
I'm showing no comments at this time.
Thank you. Thank you, Ms.
afternoon.
Castro.
Thank you.
Next one is item 22, vertical enforcement update from the HQIU from Mr. Chris and Ms. Nichols.
Yes, hello, Kathleen Nichols, Deputy Chief with HQIU. David Chris, his flight was delayed. I think he's still trying to get here. But I will be providing the update from the division.
Oh, he can turn around and leave.
Health Quality Investigation Unit. At the last board meeting, it was discussed that the 7.44 pay differential received by DCA investigators was not PERSable. Our personnel department has since notified us that the 7.44 increase will count towards an employee's retirement, which is a huge benefit for HQIU staff, and I just wanted to share that fact with you. I have a few slides to discuss the HQIU vacancies, but wanted to give a brief overview of the efforts we have made to mitigate the vacancies. A non-sworn pilot program was initiated within HQIU to hire non-sworn investigators to work the less serious, less complex cases. This has proved a valuable program, and not only has the pilot program assisted with the workload, it has provided a mechanism to identify and develop future sworn candidates for HQIU. In addition, workload was reduced for HQIU investigators by transferring the investigative work for the Board of Psychology and the Osteopathic Medical Board to the Investigation and Enforcement Unit, IEU side of DFI. We have worked extremely hard at recruiting for the HQIU sworn vacancies, and in a few minutes I will be showing you the major progress that has been made. We developed a new mailing flyer to direct mail police and sheriff's departments, as well as the criminal justice departments at all California colleges, and I think you were provided a copy of our mailer. I am pleased to report that we have mailed out over 1,200 flyers to these groups and continue to be very active, recruiting experienced candidates for our positions. Our HQIU recruitment flyer was also posted on DCA's Facebook page for more exposure. We have also developed a new recruitment video for D of I investigators, which is the first of its kind. The department had not had one. That is now posted on our blog site, and I'd like to share that with you now.
Okay, hold on. Sorry. We're not getting sound.
While she's working on that, I can continue and then we'll show the video. Another valuable improvement we have made is a change in how we advertise the vacant positions. The prior process was to post the position, which had a final filing date, and then after 2 weeks, the online applications would be available for review and you could organize hiring panels. In the meantime, new applicants could not find nor apply for vacancies until the hiring panel was completed. If candidates were still needed, you would have to repost the position, which often took a few weeks, and then the process would repeat. We have met with DCA personnel, and we now have a more streamlined process where our HQIU vacancies are posted continuously until filled. This allows us to continue each day to receive new applications. Once enough applications are received, we hold hiring panels, and candidates can still submit applications in the meantime in case more panels are needed. This also allows people responding to our flyers and recruitment efforts to always see the offices that are currently hiring so they can submit applications.
It should open right now. It was just open.
Use the PowerPoint for now if you want. We'll come back to the video in the end.
Oh, now the movie's playing.
Okay, go back.
Wasn't it? Oh, I guess not. My bad. Okay. There you go.
Okay. Regarding the vacancies, you can see that we have 27 investigator vacancies out of our 77 positions. So that's just kind of an overview, a snapshot of the percentage. With the addition of our non-sworn investigator pilot program, we currently have 17 limited-term non-sworn investigators working, assisting with the caseload, which brings the physical vacancies down to 10. We have 3 more non-sworn investigators starting in the next few weeks, which will make the total 20. All the efforts we have made with recruitment have paid off. You will see that out of the 27 vacancies, we now have 35 sworn candidates in background for those positions. 8 of those candidates have been given conditional job offers and are just pending final clearance from the medical and psychological portions of the background. 95% of candidates in this phase are successful at completing background. We have selected more candidates than vacancies to ensure that if there are candidates that drop out in the earlier phases of the background process, we have these backup candidates and won't have to start from scratch identifying new candidates. With all of these background investigations, we are ensuring they are completed in a timely manner. In order to do so, we have 16 staff members working expeditiously on these backgrounds, which report to the division's Special Operations Unit. These are RA investigators, Special Operations Unit investigators, and IEU field investigators who have had experience doing backgrounds. Now that we have a handle on filling all the vacancies, it is vital for us to focus on retaining sworn HQIU staff. D of I has recently started an official staff appreciation and recognition program called the Chief Star Program. This program is designed to recognize an employee for their stellar service to D of I. Any employee can nominate someone for a STAR Award for exceptional performance, creativity, organizational abilities, work success, and/or teamwork. This is a great way to acknowledge employees for their hard work in making D of I shine. The submission period runs from July 1st of this year through November 30th, and awards will be presented by the chief in January 2018. In addition, we are working with the Business, Consumer Services, and Housing Agency on a formal proposal for HQIU to reduce investigator workload and improve investigator retention. We will be meeting with board staff for input and are looking forward to some major changes that will end retention problems for HQIU investigators. As always, we appreciate the support this board has given regarding pay increases and other investigator retention projects, and we look forward to collaborating with board staff to implement more meaningful improvements. And with that, we'll try and watch the video.
Welcome to the Division of Investigation, also known as DOI. Since 1961, DOI has operated as the law enforcement unit of the California Department of Consumer Affairs, often referred to as DCA. DOI investigators protect the public in cases that include negligence, overprescribing, impairment, unlicensed activity, fraud, sexual misconduct, and wrongful death. Sworn and non-sworn staff members are tasked with investigating violations and enforcing the laws, regulations, and professional standards of individuals licensed through DCA. To that end, personnel use a variety of specialized law enforcement techniques, such as sting operations, computer forensics, and undercover investigations to accomplish their mission. With field offices throughout the state, DOI provides criminal and administrative investigative services for the boards, bureaus, programs, committees, and commissions within the Department of Consumer Affairs. In order to efficiently protect licensees and consumers, DOI is organized into 4 specialized units. The Health Quality Investigation Unit provides investigation and enforcement services for the Medical Board, Physician Assistant Board, and the Board of Podiatric Medicine. The Cannabis Enforcement Unit services the Bureau of Cannabis Control. The Investigation and Enforcement Unit provides services for all other Department of Consumer Affairs entities. The Special Operations Unit conducts internal affairs and background investigations of DOI and DCA staff. Consumer protection is our highest priority at DOI. This is reflected in our goal of always doing what is right for the public and their client boards, bureaus, programs, committees, and commissions. For more information about DOI, or if you are interested in career opportunities within the division, visit the Jobs tab on our blog site or contact us at 916-515-5100.
And that concludes my update. I'd be happy to answer any questions you might have.
Yeah, that looks like U.S. Army commercial. Judge Feinstein.
I have a question just so that I understand. Oh, thank you. In terms of your recruitment, do you consider hiring post-certified, retired, be it police, sheriff, CHP, but because they're able to retire at a younger age than others, do you consider them for these positions? Because everybody in the video anyway looked pretty young.
We do, and we have been actively recruiting those. The difference is if they retire from an agency that is not PERS, then they can come work for us when they retire. But if their agency that they retired from is PERS, then they can't retire and then work for us. But there's several police and sheriff's departments that are not part of PERS, and not only have we been recruiting, but we've actually been interviewing and hiring those candidates.
Let me ask you a question. Isn't there the ability to hire people who retire from PERS agencies for a limited number of hours per year?
You can become a retired annuitant, which is after you retire, but that is a part-time position, and you can only work so many hours a year.
And so that's kind of off your radar.
Well, we do have retired annuitants that do work for us. A lot of those are our own investigators who have retired, and then they come back as a retired annuitant. And if we need additional help, we often look for those candidates as well. There's actually a website that lists all those people who are retired that are interested in work, and you can match them up by category. And in fact, we're interviewing now to fill our Operation Safe Medicine unit with retired annuitant investigators, and we've gotten them off that website.
Thank you.
Dr. Lewis.
I feel your pain sometimes with hiring, recruitment, and retention. I mean, also being in a state agency, we go through the same thing in CDCR with doctors. We hire doctors in a year they're gone because there's no incentive to stay, there's no recruitment bonus, no retention bonus. And you talk about recruitment retention. I assume that's monetary for 1 year, maybe. I don't know what it's come up with.
Yeah, the 7.44% is permanent. It is for those individuals who are tapped out in the salary range for 12 months.
Right.
They would get that additional 7.44% pay raise, and that was for all DCA investigators. So that's part of it, the financial issue. The other big part about retaining is the workload, and that's what we are going to be very focused on now, is dealing with the workload situation so that we create an environment for our investigators where the workload is manageable and they will want to stay and not leave to go to other agencies.
Okay, so your increase in the salary is all of similar type of level employees. So not just your group got the salary increase, but also the competing group.
Two of the competing groups, the other divisions of DCA received it, Dental Board, and also the Department of Insurance. However, there are several Unit 7 agencies that were not included in the pay increase, DMV, Social Services, there's some others. So we've also been recruiting with those agencies.
Okay, and my last question is, how did the board help you? I want to know, every meeting, we talk about recruitment, retention, hiring. I mean, since I've been on the board for 5 years, it's the main focus of a presentation. Sometimes you like to hear about something a little different, but how did we help you?
I think the main part was being supportive of the pay increase. It was something that we've been trying for over a decade. So just having the repeated support from the board, and as those proposals move forward and having the board support that, and also just to be open to our proposals in the future about reducing the workload for the HQIU investigators. And we'll be presenting a formal proposal, and we look forward to working with the board on that as well.
Thank you.
Thank you, Ms. Nichols. Even though our investigators work at a different place, we consider them, they're part of our team. So one of the ones we are looking at, we did then the strategic plan, is that all the entities and all the people whose services we pay for, medical board, have to be accountable for timelines and so on. That includes our investigators, our expert reviewers, and AG's office. We really want to make sure that our goal is to shorten the timeline. So that's all we're trying to do, and we expect full cooperation from our own people anyway. So it was, I can tell you that, it was so much fun when I was at LA for the implicit bias training. I saw a lot of our investigators. So it was actually a pleasure to see them and talk to them. Any other questions from the board? Any comments from the audience? Comments on the phone?
I'm showing no comments at this time.
Thank you. Okay, where are we, Kim? Okay, we're going to agenda item 23, discussion and possible action on proposed regulations implementing the Physician Health and Wellness Program. Ms. Kirschmeyer and Ms. Webb.
Well, I think it's almost afternoon now, so good afternoon. So we're going to walk through the regulations that are in your agenda, but first, before we do that, I really want to thank Ms. Webb for her hard work on this document. It's interesting because as I review things that come across my desk, I have to pull out all these documents to make sure nothing got missed. And when Carrie sends me something, I'm going through and I'm like, oh, check, check. She has all of the documents because we have to make sure that these regulations comply with the uniform standards and the law as it's written. And so she did a great job, and this was actually a lot of work to put this document together. The document you have, it's under agenda item 23, and that's on pages 23-1 to 16. It's based upon several documents, and so we're going to walk through that. Again, it's the regulations. These are going to cover the Business and Professions Code, the uniform standards, and as many comments as we can incorporate going through the interested parties portion while still remaining in compliance with these two documents. So obviously, some of the comments we couldn't take. I also wanted to take a moment to go over the new regulatory process that these regulations are going to now fall into as they move forward, because it has changed from our normal process. So if the board approves these regulations today, instead of us filing these with Office of Administrative Law and then holding a hearing at our January board meeting, we actually have to finalize the packet, and including that notice to the public, an initial statement of reasons, and a fiscal impact. And we actually have to now provide that to the Department of Consumer Affairs. So once the department reviews the documents, they will provide the board with any feedback they have. Then they actually have to send the regulations on to the Business Consumer Services and Housing Agency for their review and approval. Then once they're approved at that level, then we were actually able to file them with the Office of Administrative Law and then set it for a hearing. So I think I've heard it's taking about 6 months for this process, if not longer. So I anticipate that we may be able to have a hearing on this issue at our July, or if not, then at our October board meeting of next year. So it's kind of like it used to be that the review period took longer on the back end. Now it's longer on the front end, but hopefully that'll make it move smoothly after it's approved through the regulatory hearing. So now I'm going to kick it off to Ms. Webb to actually walk through the regulatory language.
All right, thank you, everybody. So first, I want to thank everyone who attended our 2 interested parties meetings. Putting together regulations, I do my very best to capture everything that I think should be in there, but I welcome feedback and input if I did miss something, if something isn't worded well, if there needs to be a definition, or something should be stricken. And so that's an open invitation throughout this process, which I think will be quite long. The other thing I want you to keep in mind is that if the Department of Consumer Affairs decides to change Uniform Standard number 4 or any of the uniform standards, because they always have that ability to bring the committee back together again and look at this, then obviously we'll be looking at a new document down the line. With that, I'm going to turn to what I have included here. And of course, I started with the statute, which gives us the authority to do these regulations to create the Physician Health and Wellness Program. And worked from this as a starting place, worked from the uniform standards, and put together this structure. And so it's broken up by definitions, the overall requirements for the Physician Health and Wellness Program. There's several subsections under there: general, what's required for biological fluid testing, support group meetings, clinical evals, etc. That's quite a long section, and a lot of this is directly from the statute requiring the board to comply with the uniform standards. On page 13 of this agenda item, you'll have the section dealing with the report and public disclosure of practice restrictions for participants. This applies to both self-referred participants and board-referred, those which would only be those physicians who are referred because they're on probation. This is directly from the uniform standards, which does not differentiate between self-referred and board-referred. If there is a practice restriction, it is posted on the physician's profile. The next section is the reports of participant violations, withdrawals, and terminations to the board, and then inquiries by the board to the program and what the program would have to provide us. If there is a major or minor violation by the self-referred physician or the board-referred physician, that gets reported to the board, and the board takes action as appropriate. The next section is the vendor communication with the board. Obviously, there's going to be a lot of data that the board will be interested in seeing to ensure that the program is doing what it's supposed to do, and who it's helping, what services are being provided, and the success of the participants. Are they returned to practice and being able to maintain their sobriety? The next section is on page 15. This is the external independent audits. And again, this is a requirement, and the it's every 3 years or as requested by the board that this audit needs to be done. And this is to ensure both that the vendor is being compliant and the contractors that they use to provide these services are doing what they're supposed to do. And the vendor is required to monitor their contractors so that if reports are needed, they need to know that the contractor is providing those reports. And they do have an obligation to terminate the contractor if that's not being done. So the final section is on maintenance of records. This is not a something that's described in the statute or in the uniform standards. It is something that the FSMB recommends. This isn't their direct language, but we do need a section dealing with maintenance of records. And so if you see an issue there, there's a lot more flexibility with how that's handled. So with that, I am happy to answer questions, go into a lot more detail, whatever you like.
Okay, questions from the board. I'm going to just take the comments and questions from everyone before we ask for a motion. Dr. Levine.
Just a technical question. What is the administrative process for bidding the contract to vendors?
That I have to turn over to Ms. Kirkmeyer.
So once the regulations go into play, we will actually have to put together a request for proposal that'll have the entire, basically the regulations almost put into what is required of that vendor, and then we'll have to go through a bid process. I believe, and I'm gonna actually maybe look to Miss Lawley when they went through it for other boards. I think they're really looking at it for, first of all, you have to be able to say that you can comply with all of the requirements. And then the second thing, usually with bids for these types of contracts, it goes by the lowest vendor, the lowest bid from the vendor. So what they're going to be able to charge the individual who's going into the program. So it's usually the lowest bidder that can provide, still meeting the requirements, but what the lowest bid is going to be to that individual who's attending. I think that's how it's done. Yep, okay.
So I guess my question is there any weight given to previous experience with similar populations?
Not usually. It depends on how we do the contract, because there are contracts where when you do that process of evaluating, there's an evaluation process as well as the lowest bidder. But it goes through the Department of General Services, and they kind of direct us in how we do that as well. So there won't be, as long as they meet the requirements in the law, usually there isn't any looking to, have they been doing this for a while?
Or
if they have experience, although a lot of this, actually, the way we wrote it, it says that they have to have experience. So we kind of covered that in the way we wrote it, rather than thinking that the contract process was going to get us there.
Thank you. Any other comments from the board? Yeah, Dr. Hawkins.
Sorry, specific, what's the role of the medical board in the program?
Well, first of all, the statute authorized the board to set this program into place if you so desired, and the board voted to move forward with establishing this program. And it authorized the board to develop the regulations, which we're in the process now. And the board is responsible for monitoring that vendor to ensure that it's compliant with the statute and regulations.
Okay, for the audience comment, I have Yvonne Chang.
Yvonne Chung with the California Medical Association. We submitted written comments to that's related to this draft of the proposed regulations. We had kind of two sets of one overarching concern is, our concern is that these regulations do not sufficiently differentiate between those individuals who are self-referred, and for, just as a reminder to the board, those who are self-referred are those who have no pending complaints, disciplinary actions before the board, and those who are probation referrals from the board. Our read, while we appreciate the board's support in helping us get SB 1177 passed, our belief is that the intent of the bill was to create a pathway for physicians to seek assistance prior to any sort of disciplinary action before the board or any sort of behaviors on their part that would bring them before the board. That being said, one of our biggest concerns with the regulations is the disclosure or practice restrictions that are posted on the website. While we understand that the regs specifically say that their participation in the program will not be publicized, posting practice restrictions, particularly those that are imposed by a vendor who honestly does not have the authority to post to issue practice restrictions that are, quote, postable on the board's website. Really, our belief is that only the board has the ability to place restrictions on a licensee that can be publicly disclosed. Those, quote, practice restrictions placed on them by the vendor, we do not believe should be posted on the board's website. We also believe that posting practice restrictions violates the spirit of confidentiality for the participant. If the board is going to be posting practice restrictions that are imposed by the vendor, we believe this will potentially be a deterrent for any physician to participate in this program and sort of defeat the purpose of the program. Our second issue, we didn't go into detail in our comments about the language of the regulations as it pertains to the 1441 guidelines. We understand that the board needs to comply with those 1441 standards. However, we would urge the board to work with DCA to encourage them to reconvene the Substance Abuse Coordinating Committee to look at the 1441 guidelines. In the course of the stakeholder discussions, it became clear that stakeholders on all sides agree that there were problems with the uniform standards being out of date. At this point, the uniform standards are about almost 7 years old now since they were first issued, and clinical practice has changed, and we believe that it merits reopening it and a review. So we would highly encourage the board to work with DCA to reconvene that committee and work with the other health profession boards to revise those standards. Thank you very much.
Thank you. Julie D'Angelo Feldman. I was wondering, Julie, where is your slip? But it came through in the end.
I did. Good afternoon, Julie D'Angelo Felmuth from the Center for Public Interest Law. I would remind the board that the California Medical Association drafted this bill and sponsored this bill. And this bill specifically says that any program created pursuant to this bill must comply with the uniform standards. The uniform standards do not differentiate between self-referred participants and board-referred participants. And appropriately, the board's regulations do not differentiate either. I also want to provide another answer to Dr. Hawkins' question. What is the medical board's role? Your role should be vigorous oversight of this program, because this program is going to be monitoring some of the most dangerous doctors out there. As you know, you previously had a program, and for 24 years, that program was overseen by an outside committee. This board really had no role in overseeing the program. And the program during that 24-year time period failed 4 performance audits. And at that time, the board decided that it should get rid of that outside committee, and this board itself should oversee this program. You should oversee this program, and you should oversee it vigorously. And I would add to this section 1357.14, vendor communication with the board annual reports. On this handout that was back there on that table, it's BRD 23-14. I'd strongly urge you to add into this collection of information to be reported by the vendor to the board for purposes of your oversight. Not just the number of people who are in various stages in this program, but the timeframes. Timeframes were demanded by this board when it finally decided to oversee your old diversion program. So I'm talking about timeframes between when a person self-refers and when that person has the clinical diagnostic evaluation. How long does it take from the evaluation to the determination whether the doctor can return to practice, and if so, under what terms and conditions? How long is it taking the vendor to detect a relapse? How long does it take the vendor from the detection of that relapse to remove that person from work? How long does it take that vendor from the detection of the relapse to inform you so that you can appropriately cease practice that doctor and post that on your website? So I'd strongly urge you to go back and look at the time frame information that this board required of the old diversion program back in about 06, 07, and include that in your section 1357.14, because that's a part of your rigorous oversight of this program. Thank you.
Thank you, Julie. Any other comments from Michelle?
Good afternoon, board members. My name is Michelle Montserrat Ramos. I'm with Consumers Union Safe Patient Project. There are a few consumer protections we have to protect California patients, which is your mission. The standards are meant to be strict, including posting practice restrictions for a reason. They are meant to not only protect California consumers and patients, but they're meant to protect the physicians as well. If a substance abusing physician really wants to come clean and kick their addiction, they will gladly abide by the regulations. They will do so not only for the protection of their patients, but they will do so just as importantly for their own personal welfare and for the welfare of their families. So we encourage you to continue it's our intention, I should say, to continue to defend the uniform standards for not only for the protection of California consumers and patients, but for the related physicians as well. Thank you.
Thank you. Any other comments from the audience here? Comments on the phone?
Yes, there are 2. The first one's from Dr. Garza. Your line is open.
Go ahead, please.
I'm going to talk in a minute, okay? I don't know, any minute now, so.
Dr. Garza, your line is open.
It's our intention, I should say, to continue to defend uniform standards, not only for the protection of California patients, but.
Your line is open.
The next comment in the queue is from Eric Andrist. Your line is now open.
Go ahead, please.
Once again, the CMA doesn't speak for the majority of California doctors, only a minority. Most doctors choose not to be members of the CMA. Having said that, am I to understand from what the CMA rep said that she feels there are practice restrictions from the vendor that should be hidden from the public? This is exactly what we mean by the CMA's intention, being to protect doctors instead of the consumers of this state, and their point of view should be very limited in any consideration. Also, can I get a confirmation from Kim that she passed out the letters I sent to the board in care of her at the hotel yesterday? Thanks.
Thank you, Mr. Andrist. Any other comments?
Showing no other comments at this time.
Okay. So it's the time to, Kerry, you're asking for a motion?
So there's a couple ways that this can be handled. One is that you authorize staff to move forward without any changes, to submit it through the regulatory process for review, and then it gets submitted to OAL for a 45-day comment period and a hearing. And during this process, there's going to be comments that we'll have to address and make changes as the board recommends. And within that motion, I would ask that you allow staff to make non-substantive changes to move that process along. That's option one. The second option is to have us work to amend the reporting requirements to include additional data points and bring the language back for another look before it's submitted to DCA. That will delay the process, but that is an option. The comments that Ms. Felmuth made, that those can still be addressed at a later time, but I want the board to have the option to do it now before it goes through the initial process if you so desire.
Okay, discussion or a motion?
Move option one.
So we have a motion to go with the option one, and we have a second. Any further discussion? Dr. Levine?
I guess the only question is, does the board want to see, and does Ms. Webb and Ms. Kirkmeyer have access to the data reporting requirements that Ms. Felmuth referenced before we say go forth?
Option one doesn't include making any changes at this stage, but Ms. Felmuth and anyone else would submit
So it could
those
be
requests
incorporated. Got it.
during public comment period in a hearing, and it would be helpful to have language that you would like to see
Terrific. Okay, thanks.
be considered.
That's helpful.
So
And sorry, go ahead.
just that there wouldn't be any changes to this language going through the approval process, except minor stuff like a grammatical issue or a comma that doesn't change the meaning of the language.
But it doesn't preclude down the line in this
Adding it.
prior to final approval, the incorporation of comments made. Okay, great.
That's right.
And we can go back and actually pull, I have the information that Ms. Felma's asking, I can pull that and we can be prepared for it when it comes to the final hearing, and we can, it'll have to come back to the board again, but
Any other comments from the board before I go to roll call? Roll call, please.
We already did it.
We did, okay.
We did public comment, yeah.
Dr. Bolat?
Yes.
Judge Feinstein?
Aye.
Dr. Hawkins?
Yes.
Dr. Kraus?
Aye.
Ms. Lawson? Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Ms. Pines?
Yes.
Ms. Sutton Wills?
Yes.
Mr. Warmoth? Dr. Gonadev?
Aye, and the motion carries. Hey, you've been so good. Agenda, we'll go to agenda item 24, which the items for January 18 meeting. Any board members have anything to add? Dr. Kraus, and then Ms. Pines and Ms. Lawson.
Although it wasn't set as a requirement, I would like to have on the agenda the recommendation of cannabis for medical purposes agreement.
Okay,
And-
we
and-
take it for granted that it will be there because that's one we left out. So, thank you.
And secondly, in December, there will be a additional meeting of the FSMB work group, and I'd like to give an update at the January meeting on the FSMB work group to study regenerative and stem cell therapy practices.
Okay, Kim, you got that? Ms. Lawson? Okay, thank you.
I'd like to have a presentation of the disciplinary guidelines to include proposed decisions and stipulations as a review for members who've been here a couple years who have not sort of gone through that particular presentation that was given maybe about 3 years ago. Yeah.
Yeah, we took that in the strategic planning session yesterday, so I think periodically, so next meeting will be appropriate. Yes. Any other agenda item from the board members? You're hesitating, Dr. Levine.
Because I have a recommendation for an agenda item for a subsequent, not necessarily January board meeting, which is that the board hear from, and I've talked to Ms. Kirkmeyer about this, Dr. Ann Weinecker, who is the physician at Stanford who implemented their age-related competency testing policy, about their experience at Stanford with trying to address any concerns about hospital privileges for physicians with applying for privileges who are over the age of 75. And this board has looked at the issue of the aging physician, and I think her experience might be helpful to inform future deliberations on the subject.
Yeah, we'll be glad to hear. So, any? Ms.
And I just
Kirshner?
wanted to let you know too, I'm getting an individual from Stanford to actually talk about physician burnout upon a recommendation as well from a member at the January meeting, since we'll be in that area, so.
Okay. Any items from the audience? On the phone?
Yes, there is one from Eric Andrus. Your line is now open. Eric, if you're there, your line is open.
Wow, nobody was brave enough to ask for the Public Records Act to be put on the agenda. So once again, a year later, I'm asking for the Public Records Act to be put on the agenda for the next meeting.
Thank you, Mr. Andrist. Dr. Ree, I guess?
Yes, hello. Thank you for letting me speak again. So for the medical board, I was just maybe wanting to remind the medical board that there are physicians, such as myself, who do not have hospital affiliations, where in fact we do practice a great deal of prevention and education, especially for a group of patients who have Medicare. And as we know, there is a trend for decreased reimbursements, that sort of thing. So just want to remind the medical board that there are physicians such as myself who maybe don't maintain a practice or have time to speak up and attend these meetings. So I just wanted to make that statement. Thank you.
Thank you. Well, as there are no other items, we are adjourned. Thank you all for coming.